Matlab, matlab, one appellate side matter appearing in the list at item number 114 because I filed an application for quashing. I'm the married sister-in-law. 10 years back, marriage was solemnized in 10 years back. I'm residing elsewhere. And trial court is saying tomorrow is the date fixed in the trial court for evidence. Kindly.
So tomorrow is the date. Matter will be taken at 3:30 or 3 p.m. whatever it may be.
No matter, grateful if it can be upgraded is 114. Grateful, your lordship.
Lord, may I mention one, my lord? This is the testamentary proceeding, my lord. Your lordship will recall, my lord, there are two analogous proceeding, my lord. One, my lord, my application for the caretaker, and the another, my lord, is the maid now claims as a wife, my lord. Both the matters are kept together, my lord, on 1st April, my lord. In the meantime, my lord, I am supposed to file affidavit in support of caveat. My lord, now the department is not accepting my affidavit on the ground that since citation was not formally served upon us, so they cannot accept the affidavit, my lord. My lord, for that, my lord, I am seeking leave, my lord, because they are saying, my lord, until unless your lordship directs, they cannot accept the.
What?
My lord, because
Is there any direction to file affidavit?
yes, my lord.
Is there is a direction?
No, direction was not there, but your lordship says that appropriate steps
Let the matter come on the list. We'll see to that. When the matter will be listed.
1st April, my lord.
Okay.
My lord, then, my lord, affidavit is ready and we have served the copy as well.
Okay. Come on that day.
Grateful.
My lord, may I be permitted to mention, my lord, item number 17 of your lordship's commercial list, my lord. My lord, this matter, my lord, I have mentioned before your lordship on Friday, my lord, for filing of written statement and, my lord, application with sort service. The time to file written statement will expire on Friday, my lord. Lord, since the matter is was appearing under the head suits, my lord, the application has been tagged with, my lord, and is now appearing as in the suits heading, my lord. This should be, my lord, a chamber application.
Item number
70 of commercial list.
So what you want?
My lord, I want, my lord, it should appear as new chamber application, and since, my lord, time is expiring on 120 days, if your lordship take up
Have you filed the
written statement has been filed on, my lord, Friday, my lord, pursuant to your lordship's leave. Monday on pursuant to your
new motion will you?
I have
my
a
lord,
similar
if it
prayer, my
can
lord.
appear, my lord, any day, my lord, 28th is the last day, my lord.
No problem. You filed it.
I have filed.
Then
I have a similar prayer, my lord. Although I am for the plaintiff, my lord, the matter is item number 57. And my
you are for the plaintiff.
I am for the plaintiff.
So
I
what is
want
the-
this to be upgraded, my lord, under the heading of new motion so that
For what?
the application can be taken up, filed
What
by the defendant
application?
for extension of time to file written statement. I am for the plaintiff. The defendant filed this application. The matter is appearing as item number 57 in the list. So I was only praying if that can be upgraded under the heading of new motion or new chamber.
My lord, may I permit to mention one matter PLA for issuance of citation for inclusion in the list, my lord.
Yes, call the list.
No, my lord, I have another mentioning, my lord. This is for extension of interim order, my lord. My lord, the interim order is expiring today. This is a non-commercial matter, my lord. My lord, I was only praying if that it can be extended, my lord. The matter is not in the list. I have given notice.
You have not read the cost title of the cost title of the cost list.
I'm extremely.
Under compelling circumstances, the matter
But I appear for the plaintiff, my lord, in this matter.
appearing as item number 124 of the monthly list.
On the commercial?
No, as a non-commercial.
Non-commercial.
I'm suffering an interim order. There's because between the stepmother and the son, that matter Uma Chaudhary. Mr. Dashgupta has obtained an interim order of injunction. The injunction is being extended from time to time. The matter is in the monthly list. So, if the matter is affidavit is complete and Mashib has heard the matter for 1 hour, 1 day also.
Adjourn motion will
Any supplementary list.
Adjourn motion.
Adjourn motion.
Lordship, may I mention probate matter for inclusion in the list, lordship.
Yes, call the list.
This is, my lord, for correction. The order.
Yes.
My lord, kindly come to, my lord, the last page of the order, page number 3, my lord. The internal 3. My lord, the letter of administration to be granted to the petitioner. My lord, it should be, my lord, petitioner. My lord, there are another correction, page number 2. There are earlier, my lord, son, daughter, and husband, my lord, is applied for, my lord, the letter of administration. My lord. Page number 2, my lord. There is a, my lord, page number 2, my lord. Fifth line, my lord, in the third paragraph, my lord. The son and daughter, my lord, the husband was, my lord.
Where?
My lord, the sixth line, my lord, paragraph number 3, my lord. The paragraph started with the testator Purnachandra Mondol. My lord, the sixth line, my lord. The son and the daughters, as well as, you know, the husband. All three are, my lord, they applied for, my lord. Son,
The
daughter.
executives Maya has also expired, leaving behind her husband Dilip Roy and son.
Raju Roy and daughter Sagorika Roy. After the death of executive, son and the daughter as well as the husband, both three, my lord, all three, my lord, are applied.
Who husband? The strict husband.
Yes, my lord. Now let's see the cost title, my lord. Dilip Roy,
Testatrix.
executive, my lord.
What is the name of the testatrix?
Purnachandra, my lord, my lord, the original, the Purnachandra, my lord, the executive, my lord, the Sagorika Roy. My lord, he died leaving his son, daughter, and husband. Your lordship was mentioned in earlier paragraph, earlier sentence, Dilip Roy, Raju Roy, and daughter Sagorika Roy. Both, all are three, my lord, they applied, my lord. Let's see the cost type.
It was earlier also corrected.
Corrected with regard to your lordship was granted letter of granted.
So that time you are not.
It was found after accepting.
Sorry.
After accepting the
Every time that cannot be.
After accepting.
You come with an application.
Yeah, after earlier, my lord, that was, my lord, granted.
Every now and then you are coming with the one correction.
No, my lord, that is, my lord, not
Come
my
with an application, I will say.
not my lord. Kindly appreciate, my lord.
Sorry.
Instead of petitioner, my lord, this to be petitioner, my lord.
I find in all application, all paragraph, it is recorded as a petitioner, not petitioners.
No, my lord, you also kindly see the paragraph, my lord.
Kindly come to read the first paragraph. First paragraph, read first line.
The petitioner.
Then petitioner.
But petitioner should be, my lord. It should be petitioner.
Where is the petitioners? First line petitioner is mentioned.
The petitioner has applied for present application for grant of letter administration of the last will and testamentary of the deceased Purnachandra Mondol. You also kindly see the paragraph number, page number 2 of the internal.
Read the original.
Right.
Where from you got?
This order was corrected, my lord. Then now, my lord, you also kindly come to paragraph, page number 2, my lord. Your lordship was quoted the order.
Okay, you come with an application. It is very confusing.
Well, kindly see the order.
Sorry.
My lord, this has come at my instance, my lord.
My lord, I appear on behalf of the defendant, my lord.
I have mentioned the matter, my lord, for the purposes of issuance of
Item number?
Item
my
two,
lord.
my lord. This is an originating summons suit, my lord. The time and date, my lord, for the purpose of final hearing, my lord, has to be fixed by my lord, my lord. That is the reason why matter was mentioned. My lord, the mode of service indicates that the defendant has appeared.
My lord, I have even filed my wakalatnama before the department after seeking leave from your lordship, my lord. My lord, subject to correction, my lord, whatever falls from your lordship, I would like to use a written statement to this effect, my lord. Because there are certain points regards the maintainability of this suit, my lord.
This is an application. What you want?
My lord, it's an originating summons suit, my lord. Pursuant- No, no.
You filed the chapter 13 application.
My lord, yes, my lord.
Correct.
Chapter 13,
Correct.
pursuant to 16B, my lord.
Correct.
Lordship has to fix up a date for final hearing, my lord. Kindly have a look at the provision of 16B, my lord. Date and attendance. May I
So when
read
it was served?
my lord, it was served. My lord, I have
On
handed over the
on 28th January.
Yes.
Through process server.
My lord,
And through the postal service, it was served on 17th January, in 21st January. Yes. So what do you want?
my lord, I have filed my wakalatnama.
My lord, Lordship has to fix a date for final hearing of the matter, my lord.
Correct.
Notice is there, my lord.
Correct.
Lordship's officer has to put down the date therein, my lord, pursuant to Rule 16B. Kindly have a look at chapter 13, Rule 16B. Yes, my lord.
Yes.
16B, date or attendance. where an appearance has been entered by any party to an originating summons, the day and hour for attendance thereunder shall be ascertained from the judge through his officer, and notice thereof shall be given to the party or parties appearing. Such notice, unless the judge shall otherwise direct be served not less than 4 years before the returnable date. Although the notice is before your lordship, they have been served, they have
Yes.
entered appearance.
Yes. So it was served on 28th of January.
Yes, and they have entered appearance, they
They
have filed wakalat.
Okay. So you want a date is to be
Yes,
fixed.
Yeah, my lord, my submission would be to this effect, my lord. I am straight away questioning his right to maintain this particular suit in this present form and manner. Because previously, my lord, in the
An application for dismissal of the
no, my lord, I would like to take use a written statement to that effect, my lord. That is what I was beseeching your lordship to kindly lordship grants me leave to file my written statement so that I bring up these facts on record. Because
when you receive the writ of summons,
my lord, in the month of January, my lord, 28th January, thereafter,
leave is required.
no, my lord, I will file the written
Original summons.
originating summons
If you
suit.
wanted to contest, what is the duty of the defendant to do that?
My lord, I will
Leave
file.
is to be taken from the court for filing written
My
statement.
lord, I will file the written
So when
statement
you
to
have
that
mentioned the
effect.
matter, then you walk up and starting.
No, my lord, I had
mentioning the matter
filed the
without taking
wakalatnama and entered appearance
You
pursuant to.
entered appearance. Have you filed the written statement?
No, my lord, not till now, my lord.
Then today we are March,
My lord, I will
and
bring.
you are received on 21st of January.
My lord, kindly appends me 2 weeks time within which I will file the written statement.
Sorry.
Because, my lord, this defense has to be taken, my lord. This suit is not maintainable, my lord.
Milord, make a short submission. Milord, I had, Milord, I am appearing for none of them. Milord, this pertains to a trust. Milord, I am, Milord, the widow of Milord, the principal trustee, Milord, who has now died. If Milord kindly, Milord, just have a look at Milord Rule 3 of Milord Chapter 13 once. It says, Milord, upon whom Milord the summons, Milord, is to be served. It's not that Milord only Milord whom he chooses Milord to implead as a defendant, he will serve summons upon him, and Milord will not Milord serve upon any person interested. Milord, he is under an obligation under Rule 3 of Chapter 13 to serve summons upon me as well. My lord, I have not been made a party, no summons served upon me.
My lord, now the
I
question
don't-
is, my lord,
I don't
previously.
need to do that. I don't.
Not at this stage, my lord.
My lord,
May
My lord, the
my lord make my submissions without any interruption.
trust.
My lord, I have not interrupted him. I have not.
Let the matter
interrupted
go
him.
out of the list. The London advocate for the petition is not allowing the other advocates to argue the matter.
Great.
Let the matter go out of the list.
Great.
Yes, call the matter.
Great.
Call the next matter.
Finish this submission, my lord. Right? Kindly do not take me on this. My apology.
My lord, this application is appearing on my behest, my lord. There is a small correction in the order,
Yes, what is the correction, sir?
lordship. My lord, the name of the daughter has gone as the wife.
Which
and-
page?
My lord, the second page.
ये मनतोष क्या हमारा यहाँ फिक्स ACR लोग नहीं है? ARC लोग फिक्स नहीं है? क्यों हमेशा चेंज होते रहते? जीबी कौन है? So why always it is change the ARCR? Tell the court from in my court, no officers can be changed. Every day the correction is coming because all the new persons are coming, they are not understanding. And even they are not checking the from the record.
But the death certificates are at page 20.
Testator died on 26 January. The wife of the testator predeceased to the testator who died on 9th November. Where is the death certificate?
My lord, page 25 and 26 of my application, PLA.
Ninth November. Yes.
24 and 25, lordship.
And one of the daughter, namely Swati,
Swati
died on 30th January.
Swati's death certificate is at page 23.
So appearing for the petitioner. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner for correction in the judgment order dated 17th March 2025. Counsel for the petitioner submits that in the order dated 17th March 2025, in page number 2, paragraph 4, line number 3, the date of the wife of the testator is wrongly recorded as 30 January 2020, 30 January 2020 instead of 9th November 2020. Similarly, in line number 4, the name of the daughter is wrongly recorded as Gayatri Ghosh instead of Swati Ghosh. And in the 5th line, the date of the death of the daughter is wrongly recorded as 30th January, wrongly recorded as 9th November 2020 instead of 30th January 2020. Okay. Good stuff. Consider the submission made by the counsel for the petitioner. The paragraph 4 and in the order dated 17th March 2025, page number 2, paragraph number 1 shall be read as unit comma. Counsel for the petitioner submits that the testator died on 26 January 2021, full stop. The wife of the testator was predeceased to the testator who died on 9th November 2020, full stop. He submits that one of the daughter, namely Swati Ghosh, was also predeceased to the testator who died on 30th January 2020, leaving behind her husband and one son. Inward comma close. Then instead bold up. Instead of this recorded. This order may be incorporated with the order dated 17th March 2020. Great.
For the plaintiff, my lord, may I file my suggested issues?
My lord, I'm also giving my suggestion.
Yes.
I've given my suggested issues, my lord. My lord, humble prayer. I have filed affidavit under section 65B 4C of Indian Evidence Act. Can I put it on record with my lord?
No, that at the time of evidence.
That's evidence.
When you will adduce the evidence on that day, you bring that.
My lord.
My lord will see both the issues. Possibly the issue suggested by the plaintiffs also covers the issue suggested by the defendant.
Let me see the first. I will give the preference to the plaintiff.
No, my lord. My lord,
I'm the plaintiff.
kindly give the
Counter claimant.
They are the plaintiffs, my lord. Kindly give preference to them.
We're all equal before my lord.
My lord, my lord. একটা আমাকে দিয়ে দেবেন একটা কপি আমাকে দিয়ে দেবেন বলুন তো এটা তো হ্যাঁ থ্যাংক ইউ
Why you are challenging the cause of action?
Cause of action, my lord, actually this was not supposed to come under the original
No,
jurisdiction,
that's original jurisdiction.
my lord.
So that is not a cause of action. That is a jurisdiction. That 5. Cause of action already is there.
And cause of action, my lord, because they have filed a defamation and the emails were sent to the
Correct.
authorities.
Because
So,
they are treating the email as a defamation. You have
My lord.
that you have taken into consideration of 3.
my lord,
Correct. So that is the cause of action. So 4 I am not taking.
no
5
problem.
I am taking. Okay, jurisdiction let will be decided. So with regard to this paragraph, issue number 6.
My lord,
Issue number 6 is covered in the issue number 8 of the plaintiff.
my lord,
Whether the defendants are entitled to any counter claim as against the plaintiff.
my lord.
Correct.
My lord, their issue number 7 may not be relevant because there is no prayer also to that effect for demolition of the.
No, my lord, the reason
No,
is
concern illegally because their contention is with regard to the violation of the
exactly,
rules.
my lord.
Then their claim is harassment because of the.
The violation
No,
of
not
the
only
rules.
harassment.
That's why this is connected with the 3-7. With regard to
It may go into merits, but that was one of the issues before NCDRC, which got dismissed.
no
Went up to-
in the suit, they have stated that with regard to that is that you have not constructed in terms of the plan, and he has made a complaint to this.
That is the reason why I sent the
Petition
emails.
also no success.
Whatever.
No, no,
then you-
it is under
and 8 I
fresh-
am not
fresh
taking.
writ.
8 I am whether the suit is liable to be dismissed with heavy cost.
My lord.
Entitled. So I am taking all of the issues of the plaintiff and your issue number 1, 2, 3, 5 and 7.
My lord, my junior is here, Mr. Shah, may I? My lord?
So and so suffering for the plaintiff. So and so suffering for the defendant. Both the parties have filed their suggested issues. Let the same be kept with the record. At the so and so suffering for the plaintiff and the defendant is appearing in person. Okay. At the learned counsel for the plaintiff and the defendant in person peruse the pleadings and the suggested issues. The following issues are framed. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Okay. Full stop. Have you filed the judge's brief? No. Mr. Shah?
Okay, my lord.
The plaintiff is directed to file judge's brief of document after serving the copy to the learned counsel to the defendant within 3 weeks.
Yes.
Within 3 weeks, full stop. They are non-commercial, no?
Non-commercial.
Full stop. This is the matter for witness action. On 25th June at 2 p.m. for
My lord.
witness action.
Very kind of you, my lord. Much obliged.
Item number 5.
My lord, I appear for the plaintiff in this matter. My lord, this is a matter, my lord, where I have really been shunted from pillar to post. My lord, I had filed this suit originally in the commercial division, my lord. Lordship will remember the borrower's suit challenging, my lord, termination of OTS by the bank. Mr. Moinak Bose is appearing against me, my lord.
Now, first of all, you tell me.
Yes, my lord.
You file the suit, no problem.
Yes.
Without the presentation, the plaintiff, whether the GA can be registered, interlocutory application can be registered.
My lord,
Without presentation.
No interlocutory application been filed here.
इसमें नहीं है ये वाला केस है इसमें ये वाला
Now I'm no longer urging, my lord,
Okay.
urgent
No, I
interlocutory.
think in another
Yes,
matter.
there. So, my lord, here, my lord, I'm only praying today for, my lord, clause 12 leave under the latest patent and, my lord, order to rule to leave. That's all. And your lordship had been pleased to grant the same leaves, my lord, in the
Why clause 12?
clause 12, my lord, because lordship will just kindly see. Paragraph 44 and 45 are my averments, my lord, in the plaint. My lord, OTS scheme is sanctioned, cancelled and withdrawn, my lord, for within the
that one.
jurisdiction. Yeah, that one. That one. Within the jurisdiction, but some of the banks are outside.
Okay.
And my lord, it's a damage claim, so order to rule to also.
So and so suffering for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 87, 59, 06, 120. And along with interest at the rate of 18% per annum. Counsel for the plaintiff prays for leave under clause 12 of the latest patent as well as under order 2 rule 2 of the Code of Civil Procedure. Adjournment counsel for the plaintiff peruse the materials on record. Leave under clause 12 of the latest patent and under order 2 rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by most grateful.
Milord, item number 6, Milord, is my suit.
Yes, Mr. Tell me, sir, without the leave, without the presentation of the plaint, whether the GA can be filed, can be registered.
Milord, in this case, we have not, Milord, we have filed, Milord, but it's not listed.
No, no,
We
no.
have, Milord, we are aware of
It is listed.
GA1.
GA1.
Yes.
Oh,
GA1 is listed.
Milord, I was. Oh,
So
Milord, I
that
was,
is the
Milord.
problem because that is now due to the computerized system. Once
Oh.
it has been registered, automatically it will come
No.
as the GA
Oh,
along with the
Milord,
suit.
I was given instructions to pray before Lordship for the listing of GA tomorrow.
Now,
Because
that's
I'm aware
correct.
of.
That's correct. That's correct.
Milord,
But
keep the GA tomorrow, Milord.
I will keep the GA tomorrow, but please, I am passing an order,
No.
judicial order to the department. If the plaint is filed, unless it is not been presented, please not to register any GA. Let the plaint be presented
Well,
and thereafter whatever the
yes,
GA.
yes, I am aware of Milord's view. Milord, I have told Milord to keep it tomorrow. Milord, I'll pray for that leave to keep it tomorrow.
Yes, what
Milord,
is the
Milord, this is Milord the suit for defamation. Milord, both the plaintiffs and defendants are outside. But Milord, I have received Milord the publications over LinkedIn. Milord is being done. The post is being posted in LinkedIn. Milord in the Milord platform defend number 2, and Milord it is being circulated through Milord all over the world. Now, Milord, I have received, Milord, seen this defamatory post, Milord, where I was within jurisdiction of your Lordship's court. Milord, I pleaded at paragraph, Milord, 38, 39, 40, at page 11 and 12. Now, Milord, paragraph 72, I have also pleaded, paragraph, page 20. Then, Milord, 77, 78, 81. I was praying for clause 12, and Milord, as Milord, he is publishing, Milord, on a daily basis. This is being posted, Milord, on LinkedIn. Milord, I also prayed for Milord order to rule 2, Milord, because I have Milord asked for damages also.
so and so appearing for the plaintiff. The plaintiff has filed this suit praying for a decree for a sum of rupees 300 crore and rupees 250 crore as special damages and allied players. Plaintiff has prayed for leave under clause 12 of the latest patent as well as under order to rule 2 of the Code of Civil Procedure. Counsel for the plaintiff submitted, though the plaintiffs and the defendants are outside of the jurisdiction of this court, but the cause of action arose within the jurisdiction of the court as the plaintiff has received the defamatory mails and publication.
Milord, post, defamatory posts.
Defamatory post within the jurisdiction of this court. Police to counsel for the plaintiff further submit that there is every apprehension that the future claim for damages may also occur, and as such leave under clause 12 of the leave under order 2 rule 2 of the CPC is also required. But the learned counsel for the plaintiff peruse the materials on record. Leave under clause 12 of the latest patent as well as under order to rule 2 of the CPC is granted. Plaintiff is admitted subject to scrutiny by the department. Police. It is police. Subparagraph. Next para. It is found that the plaintiff has filed the suit in the department. Affirm the plaint on 24th of March 2025, and only today the matter was placed before the plaintiff is placed before this court for presentation. But it is fine from the record the department has accepted the interlocutory application filed by the plaintiff being GA1 of 2025 in CS 38 of 2025 without the presentation of the plaint and is placed, and the said general application is placed before this court along with the suit. In view of the above, the department is directed henceforth, unless the plaint is admitted or leave is not taken from this court for filing the application, any interlocutory application before the presentation of the plaint, the department is directed not to register any interlocutory application without the presentation of the plaint or without the leave of the court.
Milord, let this Milord the application appear tomorrow, Milord.
Application
Yes,
for interim order. Let the matter appear tomorrow.
Very grateful, Milord.
I'm led by Mr. Ray, Milord.
Under the heading new motion.
Milord, this has happened because of an order passed by Justice Banerjee when his lordship was here before your lordship. There where dichotomy appeared. That before the plaint, Milord, the petition used to be registered, Milord. Milord, this is absolutely correct. Without the plaint, the petition cannot be registered.
Absolutely,
Absolutely, Milord. But we are very grateful to your lordship. Very grateful.
Grateful.
My application.
Yes.
Well, this is a suit for declaration and permanent injunction, mandatory injunction, and specific performance.
Yes.
Both defendants are within, suit property is within. So I don't really need any leave. But because the interlocutory application, I had taken leave to move the interlocutory application today. That is why the plaint is being presented in court.
Cannot come tomorrow. I will direct the master, let it be admitted and come tomorrow.
I'll tell your lordship the difficulty. They have already broken my locks. They have not been able to change the shutter locks as yet. I am under grave threat of dispossession, my lord. That is why your lordship had granted me leave to present the plaint and move the interlocutory application today.
Okay.
Now, lordship will kindly allow Mr. Top.
My lord, I am a tenant in respect of.
Where is the GA? Yes.
My lord, initially my grandfather, whose name was Sahadev Mondal, he was a tenant. In respect of, my lord, 600 square feet, my lord, space at premises 16 Nalini Set Lane, premises number 46 Nalini Set Lane, Posta. Now, it is not in dispute, and I say this because, my lord, I have, my lord, appended those documents to show that the tenancy in respect of the premises in question is admitted. My lord, this original tenancy of my grandfather.
So this is the suit property.
This is the suit property.
46 Nalini Lane.
Yes, my lord.
Okay.
Now this premises was originally, my lord, the landlord was Kali Charan Poddar, who expired on 23rd of December 1995. My lord, after his death.
1955.
95.
1955.
My lord, 1955 is, my lord, Kali Charan Poddar.
Correct.
Yes, 55. I'm sorry, my lord. I mentioned 95 wrongly then. 55 is Kali Charan Poddar. My lord, after his death, my lord, Sahadev Mondal became a tenant under the two sons of Kali Charan Mondal. Their names are Mata Prasad Poddar and Gauri Shankar Poddar. Straight away, I will take your lordship to one rent receipt. My lord will see, my lord, from page 29. This is the, my lord, rent receipt. The typed copy is at 29A. Kindly comes to 29A. Mata Prasad Poddar and Gauri Shankar Poddar, my lord, is issuing to Sahadev Mondal for the month of December 82. Go down one shop. Date of receipt is 1st January 1983. And building number is also mentioned, my lord, at the top, 46 Nalini Set Road, Kolkata, 7,07,000. Now, I also, my lord, this gentleman, Sahadev Mondal, my grandfather, also had, my lord, necessary licenses to carry on its business from this property. These documents I have appended, my lord, at page 30 and 31. One is, my lord, from the Office of the Controller of Civil Supplies, which is, my lord, page 30. Lordship will again see, my lord, the licensed premises mentioned at 46 Nalini Set Road, my lord, at my lord, the foot of that page 30. And the next document, page 31, is, my lord, from the corporation.
What is the business?
My lord, it was selling of rice
Food
and
grains.
yes, food grains, my lord.
Yes.
And my lord, 31 is, my lord, the license from the corporation. License fee was being paid. This is, my lord, again mentioning the same premises of 46 Nalini Set, my lord, Lane.
Yes.
Now, during his lifetime, my lord, Sahadev Mondal permitted his son, who is my father, Narendranath Mondal, to do, my lord, carry on business. My lord, he was carrying on business under the name and style of Paint Me. My lord, I have annexed documents to this effect. Lordship will find at page 32.
Yes.
This is to certify that I, Sahadev Mondal, have allowed some portion of my room at 46 Nalini Set Road to my son Narendranath Mondal to run his business under the trade name Paint Me. My lord, kindly comes to the next page, my lord. The trade license issued by the corporation. My lord, at the top of the page, it's a bit hazy, my lord. A typed copy is there at 33A. Lordship may take the typed copy.
Yes. Municipal license.
Yes, municipal license for professions, trades and callings. Fifth line, Paint Me. The name of the proprietor is mentioned, my lord, Narendranath Mondal, carrying on business at 46, my lord, Nalini Set Lane.
Yes.
Now, my lord, the grandfather dies. Sahadev Mondal dies. My lord, he dies, and thereafter, my lord, rent receipts were issued by the two sons of Sahadev Mondal in favor of my father. My lord, kindly comes to page 36.
After the Sahadev Mondal, the rent receipt has been issued in Narendranath.
To Narendranath. My lord, kindly comes to page 36. The sons of my lord Kalicharan Poddar, they were, my lord, continuing as the landlord. Mata Prasad and my lord Gauri Shankar. 36, the rent receipt has been issued in the favor of Narendranath Mondal, who happens to be my father. My lord, the typed copy is at 36A.
Who has issued this?
My lord, this has been issued by the sons of my lord Kalicharan Poddar, the original landlord.
Okay.
36A is the typed copy. Lordship sees, my lord, it's issued in the name of Narendranath Mondal. Month is February 2010.
So when the father died?
92, my lord. 23rd February 1992. Sahadev Mondal dies.
Sahadev Mondal died on 92.
92. Now, after this, my lord, when this was the position, my lord, there is a transfer. This is the first transfer of the property from, my lord, the original, my lord, owner in favor of one Kelly Home Private Limited.
Yes.
My lord, kindly comes to page 38. Immediately after the transfer of the property in favor of Kelly Home Private Limited, a letter of atonement was also issued. Kindly comes to page 38.
Yes.
This is issued in favor of Narendranath Mondal. Your tenancy, my lord, kindly marks the, my lord, top, my lord, left-hand corner of the, my lord, page. It's issued by Kelly Home Private Limited to Narendranath. Your tenancy in respect
36.
of 38, my lord. Page 38, annexure F.
Your tenancy, yes.
Your tenancy in respect of one shop room at ground floor in premises number 46 Nalini Set Road, Kolkata 7. This is to inform you that we have purchased the entire premises 46 Nalini Set Road from its owner Sri Gauri Shankar, Kamlesh, Kishore, Lakshman Podar, and the said property has duly been conveyed unto and in our favor on 1st of October 2011. Vide registered deed of conveyance executed in the office. You are therefore requested to pay all your rent and otherwise charges, if any, in our favor on and from the month of October 2011. My lord, the next page is, my lord.
38 is the Kelly Home is the owner.
Owner. This is the first transfer. If lordship wants to keep a note, this is the first transfer because there has been another transfer thereafter.
Yes.
My lord, 38 is issued by the, my lord, subsequent owner. 39 is issued by Gauri Shankar and the heirs of Mata Prasad.
Informing that.
My lord, it's an undated document acknowledging this fact. My lord, kindly takes page 39.
Yes, yes. They have informed.
They have informed, again addressed to my client, my father, Narendranath Mondal.
Yes.
So, my lord, Narendranath was confirmed as a tenant. This would also appear from page 40, one of the rent bills, my lord, issued by Kelly Home, just for my lord.
So Kelly Home has accepted you as a
Accepted my father as my lord a tenant in respect of this property.
tenant.
My lord, there are my lord rent bills also. My lord, subsequently they refused to accept, my lord, so we had to, my lord, send it by money orders. My lord, I have annexed all those documents. The rent bill is at page 40 and the money orders are, my lord, from page 42.
So they accepted all.
They have accepted, yes. This position is not, my lord, disputed.
Then?
My lord, now, my lord, kindly comes to page 44.
Yes.
My lord, up to January 2015, rent was accepted, my lord, from my father and thereafter from me, my lord, the plaintiff. Plaintiff's name is Shubhendu Kumar Mondal.
Yes.
My lord, from page, my lord, 44 to 52, these are documents to show that the plaintiff has been tendering rent, my lord, by way of money orders. And Kylie has been accepting these payments. So, my lord, just to establish that I was accepted as a tenant, even the plaintiff, my lord. Now, my lord, the second transfer happens. My lord, kindly comes to page 53.
Yes.
My lord, Kelly sells the premises, the property, to defendant number 1 company. By this deed, second page, if lordship comes, internal page 2, that is running page 54, the date lordship will find 9th of December 2014.
Yes.
Now here, my lord, the list of tenants were also mentioned, though, my lord, according to me, my lord, my father's name was wrongly typed.
Yes.
My lord, kindly takes, my lord, page 65, which is a schedule appended to the deed of conveyance.
Page
65, my lord.
Yes.
Second schedule above referred to tenants. My lord, the first name, Narayan Mondal, ground floor, 201 electric meter. My lord, I have annexed the electric meter bill, my lord, the receipt also, my lord. My lord, instead of Nagendranath Mondal, it has been wrongly typed as Narayan Mondal. I am not privy to this document, but this is, my lord, the position I wanted to indicate. My lord, the corresponding, my lord, electric, my lord, this meter bill, lordship may take a note. It is at page 156, volume 2, my lord, it should be.
Uh, 156.
Yes, my lord. My lord, kindly comes to, my lord, page 156, my lord.
Yes.
The bill in the name of Narendranath Mondal. This is the last bill, my lord. The period is also mentioned at the top, my lord. I'm sorry, my lord. Volume 2 take to the.
Yes.
My lord has page 156. My lord, at the top, lordship will find disconnection notice and bill for January 2025. And left hand side, my lord, Narendranath Mondal, my father's name is mentioned. And care of Paint Me. That is, my lord, the business which I was carrying on pursuant to that letter. 157, 158 is the, my lord, payment acknowledgement.
Yes. Yes.
Now, my lord, if I come back to volume 1, my lord, I was showing your lordship the deed. 65, I was showing, my lord, last page 65 from volume 1, the list of tenants. Now, my lord, kindly comes to page 7. No, 70 to the. My lord, page 70. Again, my lord, these are documents from the Department of Post regarding, my lord, the money orders containing, my lord, the tendering of rent for the payment of rent to the defendant number 1. From page 70 onwards, my lord, I have annexed those documents. Ultimately, my lord, they refused, which prompted my client to file an application under section 21 of the, my lord, 1997.
Page 70 Addressed to you.
Addressed to me from the Department of Post. This
Correct.
is in connection with, I'll read this document. Sir, madam, in response to your letter dated 23rd October, this is to inform you that as per this office
Acha,
record,
paid to
above,
pay.
yes, yes.
So paid to
And that
pay
is,
to-
defendant number 1.
How you can say?
I'll show that. My lord, kindly sees the number, my lord, 2, serial number 2 at subject. Dated so and so rupees 200 at the director Astha Supply, address to AAT is addressed to the director Astha Suppliers Private Limited. Astha Suppliers is, my lord, the defendant number 1 in the suit.
Yes.
Now, ultimately, my lord, I had to, my lord, approach the rent controller because they did not, they stopped, my lord, even accepting that the payments which were, my lord, made by, my lord, money order. So, my lord, 72 is the application under section 21 filed by my client plaintiff against, my lord, Astha.
Page.
My lord, 72 is the application under 21.
Yes.
And, my lord, the rent control challans, which were, my lord, Lordship will find at page 75, 76 and 77. I have, my lord, 75 is for the month of November 2015 and 76 and 77 are for, my lord, October and November 2024. Just to show that for this entire period, my lord, challans where, my lord, challans are there in respect of the rent paid.
Yes.
So, my lord, this is the position so far as my occupancy as a tenant is concerned.
Correct.
Now, my lord, there is a development agreement.
So how this court is having jurisdiction?
No, I'll tell your lordship. Jurisdiction is because the suit property is within, my lord. I am the property valuation is also, my lord, meeting the pecuniary threshold.
How you valued the property?
My lord, it's a suit for declaration and mandatory injunction, my lord, and specific performance. So I have valued it, my lord, as per the suit value. Yes.
Yes.
My lord, kindly comes to the development agreement now.
Where?
My lord, at page 81, lordship will find this in volume 2. This is a document dated 26th November 2018.
81.
Yes, my lord.
Yes.
My lord sees the name of the parties, my lord. Page 84, lordship comes Astha Suppliers Private Limited, which is, my lord, the defendant number 1. And the developer is Narayani Realtors. My lord, it's a sole proprietorship concern represented by Pramod Kumar Mishra, who is the defendant number 2 in the proceeding.
Yes.
My lord, by reason of this development agreement, the property 46 my lord, Nalini Set my lord, Lane was being developed. So naturally, my lord, the persons who were in occupation of the property, the developer, my lord, along with the, my lord, defendant number 1, my lord, they came to understandings with various, my lord, tenants there or occupiers there. The understanding, one of such, my lord, as a sample, my lord, I have disclosed one understanding, kindly comes to, my lord, page 134.
You are all the party.
I'm sorry, my lord.
You have been taken into confidence in this.
Yes, yes, that is my specific plaint case. And I will show lordship a letter which will, my lord, establish this position issued by them. My lord, first I want to show one, my lord, model understanding. My lord, this is at page 134. It's in the really in the nature of a buyback thing, my lord. I will surrender, my lord, give up my possession. I will get up, my lord, same location. I will get the, my lord, space. I will buy it back at a particular rate. This is really the understanding. Lordship will find that at page 138 and 139. This is, of course, between somebody else, but I will show another document which is my letter to, my lord, justify this.
138.
Yes.
Yes.
Existing, my lord, recital, my lord, third line. Existing building is occupied by a number of tenants occupiers, and it is inevitable to reallocate and re-enter into the agreement with the said existing tenants occupiers for enabling the developer above named to demolish and construct a new building in place and state of the existing structure. It has been mutually agreed and decided tenant shall vacate the lawful tenanted portion being one go down at measuring so and so on the ground floor so and so, which is more particularly described purely on temporary basis, and handover is lawful tenanted portion after vacating it to the developer above named for developing and constructing a new building. Then, my lord, kindly comes to 139. Owner is D1, had proposed to sell out tenanted portion to the tenant after the construction of a new building at premises number 46 as per sanction plan granted. And serial number 2, my lord, kindly takes note of the rate is also agreed 4,000 rupees per square feet. Serial number 2 at page or clause 2 at page 139. Now, so far as I am concerned, 4,000 per square feet. So far as I am concerned, kindly straight away come to my lord, the document at page 150. This is issued by defendant number 1, the owner landlord. Please note that due to the dilapidated condition of the building at 46 Nalini Seth Road, we have entered into a development agreement with the developer for demolition of the building and reconstruction. You are an occupier of one showroom on the godown, one shop room on the ground floor of the said building. We request and call upon you to hand over vacant physical possession of the tenanted premises to us for constructing a new building at the said premises in consideration of handing over to you a shop room at the reconstructed building on the same terms. So this was my, my lord, agreement, and I have pleaded this also, my lord, this, my lord, understanding. Kindly, my lord, takes note of paragraph 20 at page 10 of my application.
So what has happened after this?
Now, my lord, after the development, what has happened is, I had, my lord, initially my grandfather, then my father, and then me had 600 square feet. I had shown the schedule, my lord. I have been given in the newly developed property.
Is there any agreement entered between you?
My lord, the letter?
That is
formal agreement, that kind of MOU is not there, but the letter from the original, the defendant number 1 is there. Then, my lord, the oral agreement pursuant to that letter, I have, my lord, pleaded in paragraph 20. And now possession which has been given to me in the new constructed building is, my lord, deficit of 400 square feet, which I am yet to receive. I have today, my lord, 200 square feet of space, my lord, on the ground floor. My lord kindly takes my schedule, which I have annexed at page 152. This is what I have. Dekhachi. My lord kindly comes to page 152. I have described the schedule which I have got. One shop room on the front side of the ground floor of the new building constructed at premises number so covering area of 200 square feet. I had 600. So 400 is short. And my lord, annexure, next document 153. Annexure R is the, my lord, ground floor plan. I have depicted what I have received.
Yes.
I have also disclosed a photograph, my lord, at page 155 with the shutter, my lord.
Yes.
My lord, with the shutter. Now the immediate or imminent threat is, my lord, that the collapsible, the locks in the, my lord, shutter, the, my lord, the locks which we additionally put in a shutter, those have already been broken. And so far as, my lord, the, my lord, internal locks of the shutter are concerned, they are yet to be broken. This is my present situation.
The shutter might have been the inner lock.
There is a internal lock of the shutter.
Correct.
And then there are two latches in which we, my lord,
there are
add
two-
locks. Those, my lord, latches in which locks are added, that have already been broken.
Where is the photo? The broken locks? No, you have not taken the photo.
Broken locks, my lord, I don't have photographs. I have the photograph at page 155, but I have the pleading there, my lord. And there is a complaint to the police station officer in charge posta.
Where is that?
My lord, the complaint is at page, my lord, 159. This is 20th of March. I'll just place this, my lord, for your lordship's convenience. I was a tenant of and in occupation of one shop room on the ground floor of premises such and such, at measuring 600 square feet. Originally, my grandfather, Sahadev Mondal, was a tenant in respect of the said shop room under Kalicharan Poddar, and thereafter Mata Prasad Poddar and Gauri Shankar Poddar. Upon the death of my grandfather, my father became and remained a tenant in respect of the shop room, initially under Mata Prasad Poddar and Gauri Shankar Poddar, and thereafter under Kelly Home Private Limited. After death of my father, I became a tenant under Kelly Home, and thereafter under Astha Suppliers Private Limited. Sometime in or around November 20, Astha approached me for vacating the said premises in consideration of handing over to me a shop room at measuring about 600 square feet to me at the reconstructed building. It was further agreed that, like the other tenants, shop room to be allotted to me on the ground floor of premises number 46, Nolini Shet Road, would be sold on me on the same basis as other tenants. Pursuant thereto, I had made over vacant possession of the shop room in my possession to the developer appointed by Astha, the owner of the premises. After development thereof, I have also been put in possession of a shop room at measuring 200 square feet by the owner on 22nd 2nd January 24 with an assurance that the remaining 400 square feet would be made over once the allocations were finalized between the owner and the developer. Said shop room was under my occupation and possession. I am also having electricity connection in the said premises, although the same still stands in the name of my father. Upon visiting the said shop room this morning, I found that locks of the shop room fitted by me have been removed and new locks have been put thereon by some other person, although the shutter keys are with me. On inquiry, I learned that the mischief had been perpetrated by Astha suppliers and their men and agents. In view thereof, I request you to kindly do the needful and remedy the situation. My lord, this is, my lord, the imminent threat. Today, my lord, if they take, my lord, forceful or illegal possession by even breaking the shutter, then, my lord, my suit becomes infructuous. I, my lord, today, for the time being, my lord, since it's an, my lord, at the ad interim stage, kindly considers, my lord, prayer A of the notice of motion, as well as, my lord, ad interim order in terms of prayers A and B. And of course, if, my lord, any, my lord, fact has been suppressed, they will definitely have the, my lord, opportunity to seek my lord, vacating of this order. This protection, my lord, I need to, my lord, have my possession, my lord, preserved for the time being.
Yes.
And one more document that I was put in possession of 200 square feet. I have disclosed a document to that effect also, but since, my lord, the last complaint records that, I am not bothering your lordship with that. So, my lord, kindly passes an order, ad interim order in terms of the prayers, my lord, I have made in the application. My entire argument has been summarized in that 20th March complaint, actually.
So and so suffering from the plaintiff. The plaintiff has filed the present suit praying for declaration that the plaintiff is entitled to be put back in possession of 600 square feet of shop room in the ground floor of the premises number 46 Nalini Set SCTT Set Road, Kolkata, and allied prayers. Allied prayers. Plaintiff has filed the the plaintiff has not prayed for any leave. Accordingly, let the plaint be placed before the London master for taking appropriate steps. The plaintiff has filed an application being GA1 of 2025, praying for ad interim injunction. Full stop. The plaintiff submits that. The plaintiff submits that the plaintiff was a tenant in respect of one shop room in the ground floor of the premises number 46 of Nalini Seth Road, measuring an area of 600 square feet. Originally, the grandfather of the plaintiff was the tenant in respect of the said shop room under one Kalicharan Poddar, and thereafter Mata Prasad Poddar and Gauri Sankar Poddar. Full stop. After the death of the grandfather of the plaintiff, the father of the plaintiff become the tenant with respect of the shop premises. Initially, the Mata Prasad and Gauri Prasad Sankar were used to receive the rent from the father of the plaintiff, and thereafter the tenanted premises was transferred in the name of Kylie, K-Y-A-L-I-E, Kylie Home Private Limited, and the same was duly informed by the original tenants as well as the purchaser of the property in question. And accordingly, the defendant, the plaintiff, and the father of the plaintiff had started paying the rent to Kylie Home Private Limited, and was in continuous occupation of the said premises. Full stop. when the paint shop has been closed?
Paint bill page. Malad, that is at page 32 and 33, 34 are the Malad municipal licenses, Malad.
In the
Trade
meantime,
license.
in part of the portion of the premises being used by Narendranath Mandal, na? Narendranath Mandal.
Narendranath Mandal, my father.
Narendranath Mandal, the father of the plaintiff, as in the क्या बोला? In the meantime, part of the portion of the premises being used by the the father of the plaintiff, under the name and style of Paint Me. Paint Me. And according to the municipal corporation has also issued the license for the said business. Foolish. The father of the plaintiff continued with the possession of the premises in question. Foolish. In the meantime, question and paying the monthly rent to the paying the monthly rent of the said premises continuously. Foolish. In the meantime, on 9th of December 2014, 9th of December 2014, a deed of conveyance was entered between Kylie Home Private Limited and Messrs. Asta Suppliers Private Limited for development of the premises in question. For development in the premises in question.
This was the Malad transfer of the property from Kelly to Astha. The development agreement is thereafter at page 8.
Executed. क्या बोला? Entered between Kylie Home Private Limited and Mrs. Asta Suppliers Private Limited by transferring the said property by Kylie Home Private Limited to Mrs. Asta Suppliers Private Limited. In the said conveyance deed, the name of the tenants is also mentioned as second schedule. And the name of the father of the plaintiff is also mentioned at serial number 1, but it has been wrongly recorded as Narayan Mandal instead of Narendranath Mandal. And the monthly rent has been prescribed as 200 rupees and the location of the tenanted premises is recorded as ground floor. And it is also recorded that in the said premises, one electric meter is provided. Police. After, when the plaintiff came to know that Mrs. Asta Suppliers Private Limited have purchased the property, accordingly the plaintiff had started sending the monthly rent to the Asta Suppliers Private Limited by money order. They have accepted. They have accepted the rent.
Yes, my lord.
And initially the Asta has accepted the said rent, and subsequently they have refused to accept the said rent, the monthly rent from the plaintiff. And accordingly, the plaintiff had made an application before the London Rent Controller at Kolkata and started depositing the monthly rent in before the Rent Controller at Calcutta. Full stop. On 26th of November 2018, the Mrs. Asta Suppliers Private Limited had entered into a development agreement with Narayani Realtors through its proprietor Pramod Kumar Mishra, the defendant number 2 herein, for development of the said property. In the said development agreement, it was agreed that the developer shall develop this, the tenants will vacate the property, vacate the tenanted premises, and developer will develop the premises, and the developer and the owner will allot the same portion of the tenanted premises to the tenant after construction of the new building, and the tenants will purchase the said property at the rate of rupees 4,000 per square feet.
Yes, my lord.
And the plaintiff has also agreed to purchase the same for a total sum of rupees at the rate of 4,000 per square feet of total area measuring an area, total area of 600 square feet in the ground floor of the said premises. Full stop. After the plaintiff has vacated the premises and handed over to the owner for development, and after the development, only 200 square feet portion has been handed over to the plaintiff, and remaining portion is yet to be handed over by the owner to the plaintiff. And after handing over the 200 square feet of the premises in the ground floor, the plaintiff has kept the said premises under lock and key by putting his lock in the shutter. In the shutter. Full stop. Full. Counsel for the plaintiff submit that all of a sudden the plaintiff came to know on which date?
My lord, this is my complaint date,
On
which
20th
is
March.
20th of March 2025.
20th March 2025. The plaintiff came to know that the lock put by the plaintiff in the shutter has been broken, and plaintiff apprehending that the defendants will broke the inner lock of the shutter, and they will take illegal possession of the premises in question. And accordingly, the plaintiff have immediately made a complaint to the police of PS Posta,
my lord, officer in charge,
making a detailed complaint to the police authority. But the police authority, in spite of receipt of the complaint, has not taken any steps. Now the plaintiff has filed the present suit. Counsel for the plaintiff submit that the plaintiff is entitled to get the 600 square feet in the ground floor in terms of the development agreement and the tenancy, which is continued with the from the lifetime of the grandfather of the plaintiff, but only 200 square feet has been handed over, and 400 square feet is required to be handed over by the defendant. Now the defendants, through the man and agent, is trying to disturb the possession of the plaintiff over the premises in question and taking the possession of the property illegally. And thus the plaintiff prays for an ad interim. Consider the submission made by the counsel for the plaintiff. This court find that the grandfather of the plaintiff was the tenant in respect of the premises in question. Subsequently, after the death of the grandfather, the father of the plaintiff has become the tenant, and after the death of the father of the plaintiff died on. Okay, leave it. After the death of the father of the plaintiff, the plaintiff is in occupation of the premises and running the business. The owner of the property, that is the defendant number 1, has recognized the plaintiff as tenant as they have entered into a development, as they have agreed that they will provide the 600 square feet in the developed premises to the plaintiff after vacating the premises by the plaintiff. Accordingly, the plaintiff has vacated the premises, and the defendants have developed the premises, but only 200 square feet of the portion has been given, and 400 square feet is required to be given. But in the meantime, the portion which the plaintiff is in occupation of the premises, having lock and key of the plaintiff, the defendants have broken out the said lock of the premises, and thus this court finds that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This court finds that if at this stage the defendants are not restrained from ad interim injunction, there is every chance that the defendants will broke open the lock and will take the illegal possession of the premises in question. Accordingly, the defendants are their men, agent, and servants are restrained from disturbing the peaceful possession of the plaintiff over the showroom, over the suit scheduled property, till
My lord, I have described in annexure Q, which is at page 152.
132.
152, my lord, 152. That 200 square feet space which has been allowed.
Scheduled property, that is,
And 153 is the plan.
that is premises number 46, comma, Nalin Set Road, comma, PS Posta, Kolkata, at measuring area of 200 square feet, bonded by premises number 44 by south, comma, entrance of premises number 46 by north, comma, Digambar Jain Temple by east, and Nalini Set Road by west till 23rd of April 2025, comma, full stop. The plaintiff is directed immediately to send the copy of this application along with the copy of the print and the documents to the defendants and to file the affidavit of service on the returnable date. Release the matter on 23rd of April 2025.
Great, sir.
My lord, I am for the petitioner. My lord, affidavits are complete.
Yes.
My lord, the contempt really arises out of
Which for the other side?
two orders, my lord.
Led by Mr. Mitro.
Huh?
Led by Mr. Surojit Nath Mitra.
My lord, kindly takes my petition. May I show your lordship first the two orders from where, my lord, I am complaining of, my lord.
All pleadings completed?
Yes, pleadings are completed.
Yes.
But kindly come to volume 3 of my application, pages 322 and 323 and 324 and 333.
Volume 3.
Volume 3, my lord. Kindly first takes, my lord, 322. Your lordship will, my lord, kindly recall, my lord, this is a partition suit where, my lord, the youngest son has filed a partition suit against the father. And, my lord, father and mother, and, my lord, orders were passed by your lordship. Kindly, my lord, come to page 322 first.
Yes.
This is the first order where, my lord, kindly considers 30th July 2024. Considering the submissions made by the counsel for the plaintiff, leave under clause 12, plaintiff is admitted, counsel has appeared and prayed for, counsel for the defendants has appeared and prayed for a copy of the said application. According the plaintiff is directed to serve copy of the said application to the learned counsel of the defendant. Counsel for the plaintiff has already served the copy of the learned copy to the learned counsel for the defendant. Kindly turns over 323. Counsel for the defendants on instruction from defendants submit that the defendants will not take any steps for transfer of the suit property till 31st July 2024.
Yes.
Let the matter appear on 31st July 2024. Now, my lord, kindly see, my lord, 324. That is the next day, 31st July 2024.
Yes.
324, 31st July 2024. My lord, extensive arguments made. My lord, straight away, my lord, come to the ordering portion, which is, my lord, at, my lord, page 333.
Yes.
My lord, kindly takes the first paragraph at the top. If at this stage interim order is not granted and the defendants are allowed to alienate the property, the same would be created multiplicity of proceedings in future. In view of the above, the defendant number 1 is restrained from alienating or creating any third-party interest with respect to the properties mentioned in paragraph 18A of the suit till 8 September 2024. Plaintiff is directed to serve copy of the application, documents and plain to the defendants on returnable date. So, my lord, both on 30th July and on 30th July was till 31st July and 31st July, my lord, proper hearing takes place and your lordship, my lord, injuncts them from alienating and, my lord, creating any third-party interest. Now, my lord, what do we find? We find, my lord, kindly now come to page 337.
Yes.
Annexure E, same volume 3. We find later on that, my lord, on 1st August 2024, kindly see, my lord, this is the query from the Directorate of Registration and Stamp Revenue. Let kindly come to the column which says transaction. Kindly see gift in favor of family members. Registered at DSR 3 South 24 Parganas. Deed number is given. Volume and page number is given. Date of registration is 1st August 2024. Just the day after 31st.
Yes.
Date of completion of registration is 2nd August 2024. Just the column thereafter.
Yes.
And my lord, kindly see who are the persons who have executed. Bhavarilal Sanai.
Yes.
Donor. That is the contender number 1. And my lord, Yashwardhan Sanai. Doni. Contender number 3.
Contender number 3.
I believe so. Just gives me one more. Contender number 3, my lord.
1 and 3.
Yes, 1 and 3. 1 gives to 3.
Correct.
Then, my lord, kindly see, my lord, what is the area, the description of the property is also given. This is one of those properties, my lord, 3 properties, my lord, which are covered by 18A. There's no dispute. They are also admitting that these properties are covered.
So these are the properties.
Yes. Kindly come to 339. Again, my lord, another transfer. Again in respect of 18A. Now, my lord, same, my lord, 1st August 2024. Date of registration, date of completion, 2nd August 2024.
Yes.
My lord, name of donor is, my lord, the contender number 1. Doni is contender number 3. Properties are mentioned at 340.
Yes.
And my lord, the next page is, my lord, document is at 341. All different areas, my lord, of the properties. But my lord,
So 3 deeds have been.
3
deeds.
3 deeds.
340, 341. Yes.
My lord, kindly see 341. Again, my lord, 1st August, completed on 2nd August. And my lord, donor and Doni, contender number 1 and contender number 3. And my lord, 342 are the description of the properties that are given.
Yes.
Now, my lord, we say that contender number 3, the grandson, who is the Doni, is admittedly not a party to the suit. But how do we implicate him and make him a party in the contempt is, my lord, paragraph 48 and 49 of my petition. Based on, my lord, Seward's principle, which I have, my lord, judgments to show. Kindly takes, my lord, paragraph 48 and
48.
48 and 49.
Yes.
The petitioner states that the respondent number 1 and 2 are completely under the control and clutches of his elder son, namely Rajesh Sanai, and his immediate family member, namely Yashwardhan Sanai. That's the grandson. Thus, the order passed against the respondent were also very much known or deemed to have been known to Mr. Yashwardhan Sanai, son of Rajesh Sanai. The fact that almost same set of counsels and advocate on record representing Rajesh Sanai and his immediate family members, including Mr. Yashwardhan Sanai, are representing the respondent number 1 and 2 in CS number 170 of 2024 is also proof of knowledge of the said orders at the end of Mr. Yashwardhan Sanai. In this regard, orders passed in other litigations against Mr. Yashwardhan Sanai showing the involvement of the same counsels are annexed here to and collectively marked with the letter F. Kindly come to, my lord, page 343 in this regard. 343.
Yes.
Kindly see, my lord. This order in another EC case, the same persons, my lord, are being the same set of persons are being represented by a common counsel who is representing, my lord, the respondent number alleged contender number 1 here. Lord, kindly see the appearances. Same, my lord, advocate on record, same, my lord, counsel. Not the senior advocate, but, my lord, the others.
2 and 4.
And he was also present in court.
3 and 4.
3 and 4.
But may I have a lordship's leave for 1 minute?
I am going to finish in 2 minutes.
I'll come back in the other 1 minute.
My lord. So, my lord, kindly see, my lord, and my lord, the pleading is that, my lord, he was in court on the day of 30th and 31st. If lordship requires, I can produce, my lord, the video recording also. So in this set of circumstances, my lord, kindly see what, my lord, they aggravate the acts of contempt. How, my lord? Kindly takes a supplementary affidavit, which is filed on, my lord, 7th of October 2024. Kindly takes a supplementary affidavit, which we have filed. We filed the contempt petition. They are cautioned. Orders of restraint are passed. Again, my lord, without any remorse and without any, my lord, respect for orders of court, my lord, kindly see what the contempt number 3 does. Kindly takes a supplementary affidavit.
Which volume?
My lord, only one, but the supplementary affidavit is a very, very...
Your supplementary affidavit?
Yes, my lord, supplementary affidavit, which we filed, which will show that they have further aggravated the acts of contempt.
Yes, supplementary affidavit.
It is, my lord, affirmed on 7th of October 2024. My lord has got. My lord, kindly come to page, my lord, 12. Injunction order passed. Thereafter, my lord, contempt moved. Then, my lord, kindly see what he does on 30th September 2024. He is writing to the secretary of Ashoka Flat Owners Association, one of those properties which he has got the deed in his favor. He is writing, this is to inform you that my grandparents, Sri Bhawarilal Sanai and Srimati Pushpa Sanai, have gifted their undivided shares in the said property by executing gift deed in my favor on 18 July. You are requested to make necessary changes in your records and ensure that future any kind of correspondence and maintenance bill to be raised in my name. And this is forwarded to my clients, where from my clients come to know, my lord, those documents are there after that letter, my lord. How, my lord, the secretary forwards this to my client, my lord, at page 14, my lord. Page 14, my lord. This letter of his is forwarded to my clients by the secretary, my lord. Facility manager, your lordship sees.
Yes.
To, my lord, Ravi Sanai, my clients. And that's how I get this letter. So he further aggravates the letter. Your lordship, my lord, restrains them, my lord, in the contempt also, not to further give any effect whatsoever. He again, my lord, writes to the, my lord, secretary saying that please transfer the flats in my name.
Yes.
Because my grandparents have executed the deeds of gift. But kindly see the recalcitrant attitude of the respondent number 3. Now, my lord, two things I want to show. My lord, two defenses they have taken in the affidavit. Very, very short. One, they say, look, we have not executed the deeds of gift after 30th or 31st of July. Yes, the deeds, the Directorate of Revenue and Stamp Collector shows that the deeds have been executed on 1st August, but we executed it we signed it physically and biometrics were done on 18th July, much prior to the order being passed. That's number one. And number two, they say, well, in the passing, that respondent number 3 is not a party, so he cannot be held for any contempt. Now, my lord, let us take the first defense, which they have, my lord, stated in, my lord, kindly takes, my lord, volume, my lord, kindly takes, my lord, their affidavit in opposition, any one of the affidavit in oppositions filed by the contemners. Your lordship can take, my lord, the one filed by, my lord, Pushpa's, but kindly takes the affidavit in opposition of contender number 1. Contender number 1.
Yes.
Kindly takes, my lord, paragraph 12.
Yes.
This is, my lord, in substance their defense with regard to, my lord, execution of the deeds. The document being annexure A forming the basis of the said contempt petition does not in any manner indicate that the respondents have deliberately violated the orders dated 30th and 31st. Although the query reports annexed at pages 337, 339 and 341, I showed these 3 pages, contempt petition indicate that the date of registration of the respective deeds pertaining to the suit properties is 1st of August 2024. However, the execution of the said deeds took place prior to the institution of the said suit, and therefore prior to the orders dated 30th July and 31st July were passed. Pertinently, the said query reports further indicate that the alleged transfers in the form of gift in favor of family members, in this connection copies of IGRs. So, my lord, he says, they say, my lord, all the contemners say, at least contempt number 1 and 2 say, that since we have executed it on 18th of July, much prior to the orders being passed, my lord, we cannot be held up for contempt. But kindly, my lord, in this regard, my lord, sees a judgment reported in 2017, 1 SCC 599. Can, my lord, a contemner come and say this? My lord, paragraph, my lord, 18 and 19. 2017 1 SSC 599. But kindly takes paragraph 18. Your lordship, is that paragraph 18? Yes. The order dated 8th May 2014 had directed that capital assets of the company shall not be disposed of without taking permission of this court. The expression shall not be disposed in the context connotes action or process of sale of assets. Going by section 54 of the Transfer of Property Act 1882, transfer of any tangible immovable property of the value of rupees 100 and upwards can be made only by a registered instrument. The expression only in the section is significant. The transfer comes into effect and becomes valid and effective only by a registered instrument. It is true that the document was sought to be registered in April 2013, but the registration in question was duly effected only on 2nd July 2014. Now is the important. In the eye of law, it is this document registered on 2nd July 2014 which alone effectuates transfer of interest in Katihar property in favor of the transferees. The transfer was thus effected on 2nd July 2014, well after the order of 8th May 2014. In Suraj Lamp and Industries Private Limited versus State of Haryana, this court has observed any contract of sale, agreement to sale, which is not a registered deed of conveyance, would fall short of the requirements of section 54 and 55 of the Transfer of Property Act and will not confer any title or transfer in interest of the immovable property except to the limited right granted under 53. According to the TP Act, an agreement of sale, whether with possession or without possession, is not a conveyance. Section 54 of the Transfer of Property Act enacts that the sale of immovable property can be made only by a registered instrument and an agreement of sale does not create. Then 19, the document dated 4/4/2013 did not by itself create any interest, nor did the title pass upon the execution of such document on 4/4/2013. It was only after registration on 2nd July 2014 that the title in the Katihar property passed from the company in favor of the transferees. Submission of the contemners, however, is that by virtue of section 47 of the Registration Act, the document in question would operate from 4/4/2013. In our view, the principle embodied in section 47 of the Registration Act is completely for different purposes. Insofar as the issue of transfer is concerned, section 54 of the Transfer of Property Act is the governing principle, which is quite clear. It is the date of registration of the document which is crucial, inasmuch as the transfer is effected and the title passes only upon registration. Viewed thus, it is clear that Katihar property was transferred in the teeth of the order dated 8/5/2014, and ex facie there has been violation of the order passed by this court. It is crucial to note that on 8/5/2014, the company had appeared on, this is not very important, it was party to the proceeding and was bound by the order passed by the court in every respect. Absolutely clear that when you execute is not important. When the registration is effected, that is to be taken to be the date of registration and the transfer actually. So, my lord, the transfer actually has taken place on 1st and 2nd of August 2024. You cannot, and my lord, kindly, my lord, also take the practicality of the situation. They come on 30th and 31st, they come to know they have given undertaking, and on 31st, your lordship has passed an order. Immediately, they should have instructed their concerned advocates that please do not give effect any further. Ask the registry office, my lord, to hold their registration, or at least a letter should have been given. Nothing. They did not even, my lord, kindly, most important, they did not even tell your lordships when your lordship was passing an order on 30th or on 31st that these properties have already been sold. Kindly look at the conduct of the respondents. Now, my lord, as far as the other aspect is concerned, whether, my lord, a third party is bound by orders of court and can be held up for contempt. The law is clear from Seward versus Patterson. May I hand up the book itself? I'll give your lordship a copy, my lord.
What is the citation?
My lord, I'll give your lordship. My lord, that is, my lord, 2017 2 SCC 456. My lord, I'll just find out.
2017?
2017 2 SCC 456.
Yes.
My lord, here, my lord, sorry. Here, my lord, the principle of my lord Seward versus Patterson has been again, my lord, quoted with approval by the Supreme Court, my lord. It's age-old principle, my lord. Paragraph 42 and 43, kindly, my lord, see.
Yes.
Kindly see, my lord, paragraph 42 and 43. 42, my lord. In Seward versus Patterson, the landlord of the premises concerned had obtained an injunction against Patterson, his tenant, restraining him from doing or allowing to be done anything on the premises, which would be a nuisance to the landlord, and from using the premises otherwise than for the purpose of private club. Alleging that the tenant had committed contempt of the court by allowing the premises to be used for boxing matches, the landlord applied for committal of two other persons, namely Shepherd and Murray, on the ground that they had aided and assisted the tenant in his disobedience to the injunction. The following passage from the judgment of Lord Justice Lindley are, my lord, quite instructive. Now let us consider, and I am quoting, my lord, now let us consider what jurisdiction the court has to make an order against Murray, who is the third party. There is no injunction against him. He is no more bound by the injunction granted against Patterson than any other member of the public. He is bound, like other members of the public, not to interfere with and not to obstruct the course of justice. And the case, if any, made against him must be this: not that he is technically infringed the injunction, which was not granted against him in any sense of the word, but that he has been aiding and abetting others in setting the court at defiance and deliberately treating the order of the court as unworthy of notice. If he has so conducted himself, it is perfectly idle to say that there is no jurisdiction to commit him for contempt as distinguished from a breach of injunction, which has a technical meaning. A motion to commit a man for breach of injunction, which is technically wrong, unless he is bound by the injunction, is one thing, and a motion to commit a man for contempt of court, not because he is bound by the injunction, by being a party to the cause, but because he is conducting himself so as to obstruct the course of justice, is another and totally different thing. The difference is very marked. In one case, the party who is bound by the injunction is proceeded against for the purpose of enforcing the order of the court for the benefit of the persons who got it. In the other case, the court will not allow its process to be set at naught and treated with contempt. And my lord, 43, my lord, the plaintiff had obtained injunction. Again, another case is quoted. And my lord, again, my lord, this entire principle has been laid down.
Yes.
Kindly, my lord.
The third parties also be liable.
Yes,
if
all the cases, my lord, yes, and my lord, all the cases that have been laid down till 45 and 46, my lord, and my lord, the court has finally come to a conclusion, even in that case, my lord, before the Supreme Court, 46 and 47, the third parties are, my lord, liable. The idea is that you may not be a party, but when you have knowledge, you cannot also abet. And this is what exactly the contempt number 3 has done. Knowing fully well that this order is there, he has abetted the respondent number 1 who are aged, respondent number 1 and 2, my lord, to force them, my lord, to create the gifts in his favor. My lord, he is equally guilty, my lord. Those are my side.
Thank
you. And my lord, only thing, my lord, that I do not need to, my lord, show, my lord, just, my lord, that the punishment, they have, my lord, all tendered apology, my lord. Apology, my lord, would not do, especially when there is aggravated form of contempt. Section, my lord, I was only referring to, my lord, section, my lord, 12, my lord, of the Contempts of Court Act. My lord, my lord is well aware, I'm just showing, my lord.
Yes.
That, my lord, 12(3), my lord, fine, civil prison. Also, my lord, undertaking given to court. Also, my lord, under 12(4), because 30th was really an undertaking. But he falls foul of every other, my lord, provision under section 12. My lord. And aggravated contempt, there's no question of tendering apology. Knowingly, you have done so, and you have aggravated it by thereafter also flouting it, even after your lordship had passed orders. But these persons, at least the contender number 3, my lord, does not deserve any mercy whatsoever.
Yes.
But I'm being led by Mr. Mitro. But may I be permitted to hold the court till such time Mr. Mitro comes? But till such time Mr. Mitro comes, may I be
When he
permitted
will
to proceed?
come?
But he is on his way.
Then he will come, then he will again recapitulate.
I can start. But since he is not here.
Come tomorrow?
Asha.
You take the book and
Yes, I'll give you. Officers are
so suffering for the petitioner. So suffering for the alleged contemptors. Counsel for the petitioner has concluded his argument. For counsel for the contemptors prays for time. According case is certain, let the matter appear tomorrow under the same heading.
Grateful.
ये कहाँ से? ये तो कर है मेरा मीटिंग कैसे?
My lord, Mr. Mainak, my senior Mr. Mainak Bose is appearing for respondent.
My lord,
Item
active
number
motion
9.
number 1. My lord, item number 9.
Yes.
My lord, my senior is actually in Odisha. He's attending a swearing ceremony of Mr. Justice Harish Tandon. My lord, kindly make it not today, my lord.
Generally, my lord, I do not oppose the prayer for adjournment, but this is an exceptional case, my lord. Your lordship may remember on last Monday, Mr. Shakko Sen mentioned this matter upon notice to other side. The other side was not there. And my lord, it was submitted before your lordship. It is a part-heard matter. Section Order 7, Rule 11 application is taken out by Mr. Mainak Bose's client, kept the matter pending, argued for 2-3 days, and my application for injunction was not taken up for hearing because of Order 7, Rule 11. And in the meantime, my lord, the defendants are alienating the immovable properties or joint properties in a partition suit, where I am the plaintiff. My lord, considering this aspect of the matter, your lordship's pleasure was that the matter to appear today as top of the list. Matter has appeared. Now, my lord, Mr. Mainak Bose is a senior counsel, but he is not appearing without junior. My lord, my respectful submission before your lordship is this: let the junior counsel who is engaged in the matter, we proceed with the matter. Order 7, Rule 11. And then, my lord, I shall make my submission in reply.
My lord, just a day, my lord. We can just.
Tomorrow you will available?
Tomorrow, yes, my lord. Yes, my lord.
Come tomorrow. Personal difficulty.
My lord,
He's not
my
there.
lord. My lord,
Come tomorrow. I am keeping the same position.
Grateful, my lord.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the defendant submit that, and due to some personal difficulty, learned senior advocate appearing for the alleged defendant is not able to appear before this court and prays for adjournment. In view of the submission made by the counsel for the defendant, the case adjourned. Let the matter appear tomorrow under the same heading in same position.
My lord, if it comments to your lordship, my lord, may I ask for an indulgence? My lord, I have not been protected by your lordship for regarding the maintenance of the status quo of the joint family properties.
That's why let's come tomorrow. Let
protection
Mr. Bose come. I will hear you. If it not, I will pass whatever. Let me see.
Grateful, my
Because in the absence of the senior, it is not. Then they will be in difficulty.
Grateful, my lord.
ये मनोज इसको ना कंटेंट वाला फाइल में रख दो.
My lord, appearing on behalf of the plaintiff, my lord.
Yes.
My lord, our submissions completed, my lord, has been concluded. We have filed our notes also. Today, my lord, defendant number 3 has to start their reply, my lord.
Who is the defendant number 3?
Defendant number 3, my lord.
Aniruddha Chatterjee. Acha, that one?
Yes, my lord.
Partition suit.
Yes, my
Yes,
lord.
Your Lordship, Mr. Chatterjee is
Yeah.
there. Your Lordship gives me a.
Not in the online. Where is Mr. Karmuko?
He's on his legs, Your Lordship.
In log.
Your Lordship has short pass over, Your Lordship.
Password, then only 20 minutes is there, then other matter will come. I thought okay, password.
My lord, I am Milap Choraria. My lord, I am suffering from motiabin problems in my both eyes. My lord, I am suffering from motiabin in both eyes.
Yes.
Operation will be held on next week or this week. I am going to file a writ petition in the Supreme Court against order dated 27th February 2025, passed by your lordship. That is why I am seeking adjournment of the matter till June 2025.
Yes.
I'm for defendant number 2.
My lord, on behalf of the learned senior advocate Manju Agarwal, she is busy on another court. Please pass over the matter.
So and so appearing for the plaintiff. Defendant number 1, Mr. Milap Charoria is present in person through virtual mode. And so appearing for the defendant number 2. Full stop. Mr. Milap Charoria, who is appearing in person.
Suffering from motiabin, my lord, in both eyes.
The defendant number 1 through virtual mode submit that he is suffering from motiabin and is suffering from cataract.
Yes.
And he is also going to file an SLP against the order passed by this court dated 27th of February 2025. And as such, he prays for time. In view of the submission made by Mr. Choraria, the case is adjourned. Let the matter appear on
monthly list of June. Because after filing there is scrutiny and list delay in the list also. The time taking process is there.
On 23rd of April 2025. Yes, next.
Sorry, my lord, I just missed that matter. Item number 9, your lordship, and that Mr. Bose was appearing. That is
tomorrow.
Tomorrow,
as it is.
As it. Obliged.
12 is that matter, my lord. Mr. Thakkar was leading me. We have completed, my lord, that circular transaction matter, that suit. In the suit, there was an application. Mr. Mitro had also completed, my lord. They were.
Yes, sir, my lord, I have a leader, my lord. Mr. Shuman Datlan, senior advocate, is leading me in this matter. We had, my lord, already begun our arguments in reply. I, my lord, beseech your lordship to kindly fix a date, my lord.
Pranava City.
Yes, my lord. Circuit's transaction, my application for judgment upon admission, and there are also, my lord, prayers for attachment before judgment.
So what is the prayer now?
My lord, your lordship may fix this matter, my lord, because
today is fixed.
This is item number 12. Any day and time, if your lordship.
Day and time, you know.
I know it is going to June, but if we may get some precedence, my lord.
That's it. Now I am not stopped for giving. It is listed. Whenever you get the time, you argue.
My lord, let it be in the list. My senior, my lord, would be.
Where is Mr. Dutt?
I'm not finding him.
Tomorrow? No.
Your lordship may keep it tomorrow, my lord.
As per the prayer, so and so appearing for the plaintiff, so and so appearing for the defendant, counsel for the plaintiff prays for time. According to
But
cases.
may it be next week, my lord? That could be, my lord. Next week, if it remains in the list, my lord.
Case is adjourned. Let the matter appear on 2nd April.
2nd April. It retains its
under the same heading. Yes, next.
Item 13, I appear for the petitioner. This is my formal application for bringing on record the legal heirs of the defendant number 3 who had passed away.
But I need to file an affidavit to this. I'll tell your lordship why. I need to file an affidavit. I appear for the defendant number 1. Nothing
This
survives
is
in the
for-
suit. The right to sue does not survive.
Why?
There is no right because the property has already been registered. The property in question has already been registered. So there's nothing
Registered?
Is there.
There is, as long as there is a dead
Conveyance has
person
already
in
been
the
registered.
cause title.
No,
Lordship, I
registered in the
think-
name of?
But subsequent purchaser who's also supposed to appear, but I do not.
Item 39 for the plaintiff, my lord.
Ah.
But
My
will give me chance to
application-
file a short affidavit to this because
Lordship, there's
in
no
my
question.
submission, nothing
Lordship,
survives.
first the substitution may happen.
Yes. No, on the substitution application, I'm seeking to file a short affidavit. Short affidavit only on the point of law in view of the
If it's an
substitution.
application, J4.
Yes, ma'am.
You want to file affidavit? Why?
But nothing survives in the suit in my respectful submission. But
What is the suit for?
That suit is suit concerned a particular
It is for specific performance of a contract.
That property
for
has already
purchasing
been,
a property.
in conveyance deed has already been registered.
Against? In favor of?
In favor of a subsequent purchaser who's
The
also
subsequent
supposed to-
purchaser will come in, Lordship.
He's also a party.
No, my lord, he's not a party. He's not a party, but he's intervening in the suit, but he's supposed to appear. I do not know. But short affidavit.
Let them
in view of the
disclose the
subsequent
name,
facts.
Lordship. He may be added and then the Lordship.
Okay, okay. Let him file the affidavit. He's asking for the time. What can be done? So and so appearing for the plaintiff. So and so appearing for the defendant. Defendant number?
1.
Full stop. Counsel for the defendant number 1. No, plaintiff has filed an application being GA4 of 2025. Praying for recording the death of defendant number 3 and substitute the legal heirs of the defendant number 3.
And also for correction of some typographical errors.
Also for amendment in the print. Full stop. Counsel for the defendant number 1 prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, that will be filed within a week thereafter. Please the matter on 17th, no, 23rd April.
But leave to file the.
The intending purchasers.
Come with an application. Huh?
The application is pending.
You filed an application?
That
What application? Application number? GA number?
Application number.
This is GA3.
So, Mr. Arif, you will file affidavit to the intervener application?
Lordship, with respect to the intervener application, Lordship, we have no objection, Lordship. Let him be added.
That can be added?
Can be added, madam.
Who are you?
The intending purchaser.
He, at the time when he filed the application, he claimed to be an agreement of sale holder. Now he says that he has become a purchaser.
What is your name? Sanjay Biswas. Who has purchased the
No,
property?
Rajshri Developer Private Limited.
Rajoshi Developers.
Yes. So I will take this intervening application along with your application. If the amendment is allowed, then all the things can be
Lordship.
Together.
Lordship together, madam.
Consensus suffering for the नहीं उसी में करो ऊपर में ना.
Liberty may be given to file the wakalat competency.
We file the application. Now you are filing the wakalat. What is going on in the department?
I think it's a change.
We file the application. It was listed. Now you are filing the wakalat nama.
How can it be possible without?
Oh, it can't be. But
Can't be without.
must be a
that
change
distance.
brief. Must be a change brief.
The change brief.
Change brief. Who has filed this application?
Even if it
GA2?
is change brief, it will be filed in the department.
Who is the advocate on record? Your advocate on record is? Same. Sanjay Kinodia has filed the application as an advocate on record.
No objection endorsement আছে? No.
ऊपर है ना? So appearing for the plaintiff, so appearing for the defendant number 1, and so appearing for the intervener. ठीक है? फिर उसके उसी में करो. Intervener has filed an application intervener has filed an application being GA2 of 2023 for addition of parties.
But you may record that I have no objection with respect to GA2.
The counsel for the plaintiff submit that he has no objection.
Without admitting the contents, my lord, they may be added.
Allowing the application filed by the intervener being GA2 of 2023 without prejudice to the right and contention of the plaintiff. This court find that the plaintiff has filed an application for recording the death of the defendant number 3 and substitution of the legal heirs of the defendant number 3, wherein the defendant number 1 has objected for the same and pressed for time to file affidavit in opposition. Accordingly, this court has already granted time to file affidavit in opposition and reply in respect to the GA3. In view of the above, this court is of the view the GA2 of 2023 and GA3 of GA4 of 2025 be taken up together for hearing.
Grateful.
GA2 is the matter. 3 and 4, 2 and 5, 2 and 4.
GA2, your lordship, the learned advocate on record wants to file an wakalatnama. He could not take, your lordship, the no objection from the erstwhile advocate.
No, that's why. Who is the advocate on record?
Also, Mr. Jitendra Patnaik.
That's why he is telling that the advocate on record, the Ginodia. Ginodia has filed the counsel for the intervener, press for leave to file press wakalatnama on behalf of the intervener. Leave is granted. Let the wakalatnama filed in the department within a week from date. After scrutiny, list the matter on 2 weeks, 1 week, na?
Yes, your lordship had kept on 23rd, I
On
believe.
23rd.
Your lordship.
23rd.
23rd.
Grateful,
Grateful.
your lordship.
I'm grateful.
Milord, item number 14, I appear on behalf of the respondent. Milord, they have filed a restitution application. I'm being led by Mr. Mitra. Mr. Mitra has already concluded his arguments. They have to give their rejoinder, Milord.
Milord, I am led by Mr. Singh, Mr. Anuj Singh in the matter, Milord. He's in some.
Yes, it's very bold matter.
Yes, Milord. Milord,
how many days is the hearing?
Milord, this is went on
These
for
are
some.
the citations.
Milord,
Milord, I kindly allow it to appear virtually, Milord.
is appearing.
Yes, Mr. Singh.
Milord, I am in some difficulty.
It will be
Milord,
completed.
Yeah, Milord, this had to be completed. Milord, kindly fix it on next Wednesday, Milord. Today and tomorrow, Milord, I'm some difficulty, Milord, because I have to, Milord, get ready.
I know.
Kindly, Milord, next Wednesday, Milord, I'll conclude on that day, Milord.
So-and-so appearing for the record and order. So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Counsel for the defendant press for time to argue the matter in connection with GA4 of 2023. For the interest of justice, the case is adjourned. Let the matter appear on 24th April.
Grateful, Milord.
Next.
This was a plaint of 2021 money lent and advanced. This is a change brief, your lordship. I have instructions from my learned solicitor, that advocate on record, that the Order 12 Rule 6 application, which was filed by us, was completed by us, the submissions with respect to this, and the learned defendants had started making submissions on the same, the opposition, with respect to our application. So, your lordship, they can continue the submissions. Our humble request from our end, that if they have made some submissions on the opposition to the Order 12 Rule 6, if they can provide a brief note of
I will
arguments.
tell Mr. Sen personally about what has been my submissions. I'll tell that.
You take the note what he submit.
Definitely, we
that you have a conference with your senior and inform your senior. This is the argument made by the other side.
We shall take note of whatever submissions will be made, and I shall discuss it.
But Milord, I will be, Milord, citing 3 judgments, but 5 minutes time may not be sufficient, Milord.
Not sufficient.
Lordship, Milord, can keep this matter running in the list. I have all intention to conclude, Milord. This is also going on for some time.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 9th.
I'm deeply obliged. May it please your lordship, my lord.
My lord, this is a part heard matter. My learned senior friends have already concluded their portion, my lord. Now, my lord, we are about to make our submissions. Mr. Dotto is leading us, your lordship, on behalf of the defendants.
This is, my lord, a very unfortunate situation going on with this matter. We are, my lord, enjoying an interim order. Our gate still remains to be, my lord, in a position where we are unable to operate. Because, my lord, they had consented that they would be, my lord, putting gates over the lift openings. That is my order recorded, my lord. And please let me complete. And Mr. Chaudhary, my lord, had argued the orders were passed by your lordship regarding firefighting system. It was found that there is nothing in a 9-story building and there was extreme fire hazard. Pursuant thereto, my lord, they agreed that they would be, my lord, putting the gate in front of the 2 lift openings because I am unable to use this place since 2020 December. And after that, my lord, there was a complete change of their submissions and they started, my lord, contesting this matter. We have already argued. We have made our submissions, but that, my lord, has been quite long back. Today, I would be beseeching your lordship, my lord, for extension of time, my lord, of the interim order. But, my lord, the conduct of the defendant, my lord, should be such that they are ready and willing to argue and finish off the hearing of GA1. This cannot prolong for so long.
Correct.
My lord, the 2 lifts are there. It directly opens onto my floor. It was explained by to your lordship by Mr. Chaudhary as if, my lord, it's opening directly onto this courtroom. And, my lord, I am unable to use that place. They are, my lord, directly linking the electricity charges with my maintenance charges. So whenever, my lord, I have to recharge and top up the prepaid electricity meter, they are automatically deducting it as maintenance. They have put that system in that manner. I am without electricity as on date. These are, my lord, conduct of the defendants which is adding on to.
We are on the electronics.
That is, my lord, it's becoming so difficult. But we are unable, my lord, to enjoy. We are, my lord, a tenant. They have initiated a month back, they have initiated eviction proceedings against us. Be that as it may, my lord, let this matter.
I understand, my lord, the difficulty. Now, my lord, GA6 opposition, my lord, it was not there, my lord, on the last occasion with my lord's records. We have already hand over the copy to the, my lord, the other side. Your lordship kindly takes this on record.
Which one?
GA6, your lordship.
GA6 affidavit in opposition?
Opposition, my lord. It was not there on record on the last occasion.
अच्छे
सर्विस कर दी
नहीं है.
My lord, we are willing to. Otherwise, if your lordship remembers, there were talks.
So this is with connected to GA6.
No, GA1. Your lordship, my lord, is hearing all the applications. My principal application is GA1 because that is the application where, my lord, I am asking for interim reliefs. Especially, my lord, put installation of the gate. I have even reached out to them by saying, and I have a specific prayer.
Last time
grant me leave. I can do it myself with my own resources.
Last time this court has granted, but I don't think it has been solved.
No, my lord, they are only showing the carrot of settlement.
My lord, it is
That is,
long
my lord,
gone, your lordship. My lord will
it's
recall
taking years
talks
now.
of settlement were done, and before your lordship, my lord, Mr. Chaudhary, my lord, proceeded
Lord,
with
kindly
argument.
give a peremptory direction for them to, my lord, continue with the hearing if they are interested. Otherwise, the application meets its
suffering
fate.
for the plaintiff, and suffering for the defendant. Full stop. The matter is fixed today as part heard, but learned counsel for the defendant press for time. Accordingly, case is adjourned. Press for time. Full stop. Learned counsel for the plaintiff. There is objection and submitted. The plaintiff is suffering very badly, and as such, the application filed by the plaintiff is to be heard as early as possible. Consider the submission made by the counsel for the respective indicated in counsel for the plaintiff further submit that interim order granted earlier is going to be expired on 27th of March 2025 and paid for extension of interim order. Considering the submission made by the counsel for the parties, the interim order granted earlier is extended. 3:45 की time है?
3:45 at a time.
में नहीं है, 3:45 नहीं है.
My lord is fixing a date for the hearing.
Let the matter. Probate. हाँ, 11:30 में देखो, 11:30 देखो, अप्रैल का सेकंड वीक, लास्ट वीक, 22, 23, 24 कुछ है, खाली है सब। 23rd April 2025 11:30 p.m.
I'm deeply obliged.
11:30 a.m.
I'm deeply obliged.
Full stop.
23rd
The interim order
11th.
granted earlier is extended till 23rd of April 2025 or until further order whichever is.
Grateful.
Yeah. Fine. Yes.
But I was just stuck, my lord. Sorry, my lord. It's a matter where, my lord.
One minute is also over.
Lord, I'll not take much time. It's only, Lord, we had concluded our submissions on merits. Only point of counterclaim was left and filing of the written notes of arguments. Lord, I shall file the written notes of argument today. It's ready. Lord, with respect to counterclaim, may I just indicate your lordship need not even Lord open the brief. Lord, I'll just indicate. Copy আমরাও পাইনি এক্সচেঞ্জ করে দে আমাদের তোরটা দে দেয়া হয়েছে তো আমারটা দিস না দিয়েছে তো may I পড়ে আচ্ছা ঠিক আছে Lord, with respect to the counterclaim part,
how much time will it take?
1 minute maximum.
1 minute is okay.
The claim is about 11 lakhs and odd on the account of Lord repairs. It's not in dispute. Nobody has disputed in the cross-examination also. Lord, the repairs have not taken place. So repairs have taken place. Lord, the bills that we have produced, Lord, are already on record and Lord are exhibited. And Lord, with respect to Lord, all invoices relating to the said expenses, the questions
Exhibited
or exhibited. Lord, the questions your lordship exhibited.
Not exhibited. That is the two difference they have taken. No, with regard to expenditure, there is no document, and with regard to the shares, you have not brought this agreement on record.
Lord, the agreement with respect to agreement, Lord, we have argued. Lord, I'll not repeat. Lord, I have stated that
taken note of it.
Lord, with respect to the deed of gift, Lord, that we have argued. We have given a reply to Mr. Shorka's Lord argument. Lord, with respect to the invoices, Lord, it's already on record, not in dispute that the repairs have taken place. If repairs have taken place, repairs do not take place for free. Lord, so Lord, some expenses have happened. Lord, if some expenses have happened, Lord, I'm entitled to my share. That's my only count. Nothing more.
That's thank you. Yes. Anything further?
No, my lord, so far as the counterclaim is concerned, my lord, it is not in respect of, my lord, the defendant number 2 whom I am appearing for. But it's really in respect of the plaintiff.
No, in respect of all. This is a partition suit.
Partition suit. So you, if the court find that is entitled, then you are entitled the partition also. Then the share is to be divided. Simple calculation.
Lord, so far as the counterclaim is concerned, my lord, I believe, my lord, the documents which my learned friend is relying upon have not been, my lord, properly exhibited. So, my lord, the repairs, whatever repairs they are saying, they have given a bunch of documents which have not been properly exhibited. So, my lord, I have, my lord, nothing else to say. What will appear from the records, my lord? Either they prove their claim on the basis of what they have been able to prove in evidence, or, my lord, they do not have any claim so far as counterclaim is concerned. Now, my lord, so far as, my lord, the deed of gift is concerned, I have already made my arguments with regard to that. My lord, they have not. I'll not repeat that, my lord. Lord, we'll file our notes, my lord, dealing with, my lord.
Okay, file the notes.
In fact, my lord, I have already filed my notes.
You have already filed. You have not filed.
Yes, my lord. I believe, my lord,
with
we
regard
have to.
Counterclaim, my lord, within 1 week, I'll file another supplementary note only dealing with the counterclaim because my case also no evidence.
Kindly gives me some time, my lord. We'll file our note.
So and so suffering for the plaintiff. So and so suffering for the defendant number 1.
I appear for plaintiff, my lord, defendant number 2.
Defendant number 2. Defendant number 3 series.
3
series. The defendant number 2 and defendant number 3 series. The defendant number 3 series has concluded his argument. Appearing for the defendant number 4 and 5. The counsel for the defendant number 3 series has filed the written notes of argument. Let the same be kept with the record. Counsel for the plaintiff and the defendant number 2 You also file the affidavit, written notes of argument. And the defendant number 4 and 5. 4 and 5 press for a week's time to file their written notes of argument. Let the written notes of argument filed within a week. This is the matter on 9th of April, no. 9th April 2025 has to be mentioned only for the filing of written notes of argument.
I'm great. I was going to pray for that.
Great.
My application,
Yes.
only for amendment of the affidavit of assets.
ये मन तो ये बनवाता कौन? नहीं बनाता कौन? कौन ऑर्डर देता है? कोर्ट मैनेजमेंट। ये सब तुम लोग साइज देख के नहीं बना सकते। इतना बड़ा। Yes, what is the application J1?
Yes, only for amending the affidavit of assets. We have indicated the proposed amendments to the probate petition file. You will find that from page 4 onwards. Page 4 it starts. The amendments are from page 7.
Correct the name of the testatrix in the costed of the affidavit of assets. That is granted. So now what you want?
Yes, kindly see page 7 of the application.
Page 7.
Page 7. The annexure X is at page 4. We have indicated the amendment, proposed amendment.
These are the properties. Shares. What is?
Yes, some investment. Serial number 5 at page 7.
Investment under the demat format.
Yes, of Eureka Stock and Share Broking
Stock and Shares
Services.
Broking Limited. Tata Technology.
Yes, man, we did not provide the registered address of these companies.
Oh, these are only.
Yes, and page 10, Jaiswal Neco Industries Limited, the address has been provided.
Okay. And what the name of the testatrix has been corrected in the application?
Yes, it's a now it's a Geeta Prasad alias Geeta Devi alias.
11 December order was passed. That has been done.
Yes, I'm told that has been done.
Geeta Prasad alias Geeta Devi alias Geeta Devi Prasad. Okay. So appearing for the petitioner. The petitioner has filed the present application for amendment in the affidavit of assets as provided in the proposed amendment appearing at page number 7 to 12. 7 to 12. Consider the submission made by the counsel for the plaintiff. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Nature and character of the application. Accordingly, prayer A, B, and C of the master summon is allowed.
Right.
GA1 of 2025 it is both.
Right.
Item number 60 and 61 are my applications, Your Lordship. Item number 60 is GA1, which was my application for some interim reliefs. By an order, 60 is the GA1. Which was my application for some interim reliefs, and an interim order had been granted on 4th of October, 2024. Injuncting all the heirs from dealing with the assets of the deceased. Now, subsequently, I had also sought another order for disclosure of a part of the assets which admittedly had been transmitted, some shares which were transmitted to one of the heirs, the elder daughter, Preeti Jhawar. Now, In the meantime, your lordship had directed them to directed issuance of caveat. Now we discover that they have also filed an affidavit in support of the caveat. On the last occasion, I had shown your lordship the affidavit in support of the caveat that it does not disclose any ground of objection for grant of PLA. So I had mentioned that insofar as it does not disclose any ground, the law is settled under Rule 25 of Chapter 35. It does not constitute an affidavit in support of the caveat. So it should be discharged. At that stage, I had requested your lordship to allow me some time to come up by way of a formal application. GA2 is my application for discharge of caveat.
Which for the other side? Nobody's appearing.
They have been appearing intermittently, your lordship. Some junior appeared, your lordship recalls, on the last occasion, who did not have any instruction on the matter. Then your lordship said a junior is appearing. Let them also consider and come back. If your lordship kindly sees the last order.
Yes, this application is served? No.
Yes, it is served.
So this
We
one,
have made
J2.
advance service of everything.
J2 is served.
J2 is served. Now, another development I must appraise your lordship of. In the meantime, because the time to file the opposition to my GA1 was made peremptory at my request, because they had not been filing their affidavit in that matter. Because I had sought disclosure of assets, so it was your lordship's consideration that maybe in their affidavit of opposition they will disclose. Now, in the meantime, they have filed their affidavit in opposition. It's a very interesting affidavit in opposition. They have not disclosed anything, but they have
Affidavit in opposition J1.
J1. If your lordship has it before you, there it has been filed by the two heirs, two caveatrixes.
Yes.
Your lordship will kindly take any one. The affidavit in opposition by Preeti Jhawar. It makes for a very interesting read.
Yes.
Your lordship will kindly take page 6. Right after the quoted portion, the paragraph starting, according to Honorable Supreme Court of India. Lordship, may I read that? According to Honorable Supreme Court of India, the mandatory requirement to seek letters of administration for establishing a right only arises when the party seeking it proves that he has a right as executor or legatee under a will. However, in the given case, the deceased died intestate, and therefore there is no question of taking any probate or will or letters of administration. I am unable to fathom the legality, and your lordship will also see para 8. This is something very important. My entire apprehension was the bank has told me the demat account, operating agency had told me that shares which comprised of a substantial part of the asset stands transmitted to the nominee.
Correct.
Now, para 8 says something completely to the contrary.
Para 8.
Para 8 at page 10.
Yes.
It appears, may I read? The plaintiff's ignominious action led to Sri Balkrishan Jhawar executing a power of attorney dated so-and-so in favor of elder daughter Preeti Jhawar, wherein he authorized Jhawar to transact and sign on his behalf of the equity shares, debentures and other investments either held under him, signed jointly. So merely a power of attorney holder. Now, law in this regard is absolutely settled that a power of attorney holder who is just the custodian has to account to the estate. So he is not even a nominee. And even that nominee has to account to the estate. Now here that threshold is even lower. So this is what they have disclosed. They have also said, I will not detain your lordship on this. I will file an affidavit in respect of this. They have also said, since the younger daughter had been given Sridhan, now she is not entitled to anything. This is the content. This is the sum and substance of the affidavit.
Not from Calcutta.
I have.
Yes.
So it doesn't seem they're pursuing this matter very seriously, your lordship. On several occasions, your lordship has noted that they have not been present. There have been change of advocates. Advocates without any instruction have been appearing on several occasions. And they have filed this affidavit of opposition now after October 4th, when the interim order was passed and a direction for affidavits were given by the erstwhile bench. Now,
yes. So what can be done now?
Now, in conspectus of these facts, your lordship, I will definitely file my affidavit in rejoinder to the reply to the opposition. That is one. Your lordship may direct them to file their opposition, if any, to my GA2. If not, your lordship can hear me out. I'm carrying the cases.
What is the GA2?
GA2 is for discharge of the caveat, because the affidavit does not disclose any ground.
Sons offering for the petitioner. None appears on behalf of the caveatrixes. Full stop. The petitioner has filed an application being GA2 of 2025, praying for discharge of caveat. Filed by the caveatrixes, both filed.
Both caveatrixes.
Full stop.
Affidavit in support has been affirmed by?
None appears on behalf of the caveatrix. But for the interest of justice, counsel for the petition prays for. The caveatrixes have filed their affidavit in opposition in connection with GA1 of 2024. The counsel for the petition prays for time to file affidavit in reply to the affidavit in opposition in connection with GA1 of 2024. Let affidavit in reply be filed within
7 days.
Within 1 week from date. Full stop. For the full stop. Though the caveatrixes are not appearing before this court, but for the interest of justice, the caveatrixes are granted liberty to file affidavit in opposition, if any, in connection with GA2 of 2025 within a week from date. Full stop. A reply, if any, they are to be filed within a week thereafter.
3 days. 3 days.
Within a week thereafter. List GA1 and GA2 of 2020. GA1 of 2024 and GA2 of 2025 in PLA 358 of 2024 on 23rd of April 2025. The petition is directed to communicate this order to the caveatrixes for compliance.
Very well.
It is made clear that on the date fixed, if the caveatrixes fail to appear before this court, the case will proceed accordingly.
I'm deeply obliged. One humble request, your lordship, that the interim order be continued, because the language of the interim order was...
Where is the interim order?
410. Is that
interim
the...
order granted earlier? Is extended. That is
My apprehension is, after such submissions being made, I don't know what will be construed, your lordship. And they're refusing.
The interim order granted earlier, that is on granted on 4th of October 2024, is extended till 30th of April 2025 or until further order, whichever is.
I'm deeply obliged. I'm very grateful.
Yeah. Yes.
Lord, department has indicated certain defect in the petition. Typing defect, Lord. Not just for removal of those defects, Lord. Amendment of all the cause papers.
GA3.
My Lord. Kindly come to page 7, my Lord.
Page 5.
5. Now this is not original. This word has to be deleted. That's only in all the documents filed in the court that has to be deleted. That's only a amendment.
This is only amendment.
Only amendment. But may I give you the pages numbers? All the word original has to be deleted. There's just deletion of the word original. Everywhere is testamentary. It has gone down original. It should be testamentary.
Consensus offering for the petitioner. The petitioner has filed the present application being GA3 of 2025. Praying for amendment in the only application. Amendment in the application. Amendment in the probate application as well as the affidavit of assets.
Now all the I kindly see paragraph 1 of my petition. All the documents including the Wakalatnama, affidavit service, assets,
the application for amendment in the cause paper of PLA number 472, that is petition, Wakalatnama, affidavit of assets, affidavit of Ravindra Kumar Rakheja, affidavit of Renu Duggar DUGR, affidavit of Hemant Surana, affidavit of attesting witness of Mr. Rishi Chawat, affidavit of Anish Rakheja, affidavit of Pratap Singh Rakheja, and affidavit of Srimati Prem Surana, wherein the word original is to be deleted. The word inverted comma original is to be deleted. Had the learned counsel for the petitioner peruse the material, peruse the amendment application and the proposed amendment as mentioned in, as appearing in Annexure A of the present application, this court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the original application. Accordingly, prayer
A and B, my lord.
A and B, A, B, and C, yes, of the master summon is allowed. GA3 is disposed of.
I'm grateful to you, sir. Yes.
Next.
My lord, this is my application, my lord. Post grant of letters of administration, my lord, I have taken out this application for amendment of the application, my lord. Kindly post grant, my lord. I'll indicate, my lord. This is just a technical aspect that the department has pointed out to us. Kindly takes the first page, my lord. In the goods of Niva Roy Chaudhary, testatrix, my lord, she left a will. Kindly takes page number 2 of my application. I have given the table of the legal heirs, my lord. My lord, page 2 of the application. I have set out the legal heirs. My lord, Bishwajit Roy Chaudhary had initially filed a letters of administration application. Thereafter, my lord, Rudrajit Roy Chaudhary had lodged a caveat, and Bel Kosturi Rao, my lord, had given her no objection to the LOA being granted. Subsequently, my lord, by orders of this court, Rudrajit Roy Chaudhary's caveat was discharged, and my lord, letters of administration was granted to Bishwajit Roy Chaudhary. My lord, however, Bishwajit Roy Chaudhary passed away a few months after the grant. So, my lord, Bel Kosturi Rao made an application for the letters of administration to be granted.
That was allowed by this.
That was allowed by this court, my lord. That, my lord, the order, my lord, will find at page number 22. Page number 22, detailed order, my lord, that was allowed. Now, what has happened, my lord, because the principal application contains averments for grant of letters of administration in the name of Bishwajit Roy Chaudhary, the department said that please carry out these amendments. Because that was made in a GA, my lord. We should have first made the amendment and thereafter sought for letters of administration. Kindly see page 22, my lord. The entire factual gamut has been written down here, my lord. And if my lord kindly sees the proposed amendments, may I just show it to my lord? The application starts at page 32, my lord, with the proposed amendments. So instead of Bishwajit, my lord, it will be Bel Kosturi Rao, page 32. My lord, kindly also comes to page number 41, because now it is in the name of Bel Kosturi Rao, we are seeking leave to re-verify, my lord. Page 41 I have indicated. Now, my lord will kindly see the affidavit of assets, my lord, which begins at page 44. That also needs to be now reaffirmed by Bel Kosturi Rao. And my lord, yes, Bishwajit Roy Chaudhary, my lord, page 49, my lord, the affidavit
47.
of the... Yes, my lord.
47, 48, 49.
Yes, my lord. 49, my lord, sees this was the affidavit of the attesting witness, my lord, where it was stated that it had to be, LOA was to be granted to Bishwajit Roy Chaudhary instead of that Bel Kosturi Rao, my lord. And my lord, I have asked for a few prayers, my lord. One is for amendment, my lord. And my lord, I had already shown the order. So, my lord, I have asked for prayer E also, that after the re-verification and amendment and all the amendments are carried out, the department be directed to comply with the order of 6th of February 2025, by which my lord had already granted letters of administration. And I've served on the other side also, my lord. The one who had given the death certificate, the daughter, my lord. She's not appearing.
Have you served?
Yes, my lord. Affidavit of service I filed today, my lord. Affidavit of service.
Filed?
Yes, I filed.
Sensor.
Oh, I'm so
Yes,
sorry.
yes, yeah.
Yes, my lord. They have both received, my lord. I've enclosed the tracking reports also.
Appearing for the plaintiff and petitioner. The petitioner has filed the present application being GA3 of 2025, praying for amendment. Praying for amendment in the probate application. The probate application being PL.
My lord, application for grant of letters of administration.
Sorry. क्या बोला?
And my lord may write the cause papers because it also has the affidavit of
Praying
assets.
for amendment.
Kindly cease my prayer, my lord.
For amendment in the cost papers of PLA number 549 of 2022 for grant, wherein the petitioner has prayed for grant of letters of administration. Solicitor Counsel for the petition submit that by an order dated 6th of February 2025, this court has granted letters of administration, and at the time of proceeding for administration, proceeding for issuance of letters of administration, the department has pointed out that after the death of Biswajit Roy Chaudhary, alias Biswajit Roy Chaudhary, the application for grant of the cost paper for grant of letters of administration was not amended. And as such, the department is facing difficulties for issuance of letters of administration in terms of the order passed by this court dated
6th of February.
6th of February 2025. Accordingly, the petitioner has filed the present application for amendment in the cost paper of the PLA number 549 of 2022. Consider the submission made by the counsel for the petitioner, perused the proposed amendment. This could find that the amendment as sought for by the petitioner will not change the nature and character of the application, and the same are formal in nature, and the same is required under law after the death of the original petitioner, Mr. Biswajit Roy Chaudhary. Consider the submission and full stop. In view of the above, prayer
A to E.
A to E of the probate application of the E of master summon is allowed. The department is directed that after the amendment is carried out, to issue the letters of administration to the petitioner in terms of the order dated 6 February 2020. PA number so is disposed. Next.
I appear for the caveat, my lord. So there was a delay in filing the caveat, and
Who is for the petitioner?
the petitioner was there on the last. Shananda Ganguly was appearing.
Huh?
Shananda Ganguly was appearing, my lord.
Application supported by affidavit.
My lord, we could not file the caveat as well as the affidavit in support of the caveat within time.
When you received the caveat?
My lord?
When you received the caveat?
The caveat notice.
Notice.
Yes,
Sorry.
my lord, certainly, I'll just indicate.
When you received the notice?
I'll indicate, my lord. So we received it on August 17, 2024.
August 17, 2024. And when you lodged the caveat?
I could not lodge the caveat in time.
Could not lodge the caveat in time.
We have filed an application for, previously we have filed an application.
Other side is not here. Have you served the copy?
Yes, my copies have been served.
Let one opportunity be given. So appearing for the caveat or caveatrix?
Caveators, my lord. Two caveators.
Caveator 1 or 2?
Two.
Caveators. None appears on behalf of the petitioner. The caveator has filed an application. Caveators have filed an application being GA2 of 2025, praying for extension of time to lodge caveat and file affidavit in support of caveat. As none appears on behalf of the petitioner, for the interest of justice, the case is adjourned. Let the matter appear on 9th April 2025.
Lordship, I appear for the petitioner. This is my application for extension of time to file the inventory and accounts, my lord.
When the probate was granted?
Letter of administration was granted on 21st September 23, and the LA was received, letters of administration were received, my lord, by the petitioner 17 November 2024. Lord, I am delayed by
Why
2
so
months.
why so delay?
My lord, there is a delay.
23, 24?
No, Lord, 23, my lord, the grant was issued.
Correct.
Thereafter, my lord, I had to execute the bond and justification has to be given. For that reason, my lord, there was some delay. Because normally, my lord, we do not get the bond and justification very early because the department is a very hard pressed nowadays. Even nowadays, my lord, they have also started a procedure marking my FDs as lien. That is not possible, my lord, under the original set rules, my lord, subject to my lord correction, my lord.
Since beginning, I am telling the what the procedure has been adopted.
Lord, I
here,
have a report. I have a report of the London Register Insolvency where it strictly says, my lord, there is no procedure as such.
Correct.
Lord, they are adopting that
Under
still
what
today.
procedure?
Lord, that is still being adopted now.
As per the probate, even the letters of administration, even the Succession Act, only you have to give the indemnity.
I am grateful, my lord.
You have to give an indemnity.
I am grateful.
With the only of the landed property, of the valuation of the landed property, that will be kept that, as a security. If any future it will come, then you will be responsible. That is enough.
Yes, that was there till 3 years back. After, my lord, 3 years onward, my lord, it has started like
because this. You are asking for the administration of the deceased.
Absolutely, my lord.
So for your property, you have to give the security.
And all the monies are lying here. I mean, he is asking, my lord, the London Register is asking to give the FDs, that original FD is lying with him. Today, supposing if the FDs are lost, where will...
In one case, I passed an order, Mr. Chaudhary. Jishnu Chaudhary had appeared and I passed the order, but nobody is following that.
Something has to be done. Your lordship has
passed
to.
an order.
But still, my lord, I am also pursuing another matter before Justice Shogoto Mujumdar. My lord, there his lordship has held that his lordship will go through it and my lord, I shall come back.
I had held.
But it's very difficult to this department, people.
Relying the judgment passed by the Delhi High Court, I think, yes, Delhi High Court, I had held that it is not necessary. Only the personal bond.
That was there, my lord.
Maximum, it is the indemnity with the securities of one surety. And indemnity is not that the surety is to be given.
My lord, they are even asking the original FDs. I question, oh, very well, I do not have the money. I want to deposit the title deeds. They said, no, I will not.
When I have been given the determination, then I inquired from the department. Department is telling that this is a procedure adopted.
Where is the nothing? Lord, even the register does not pass any order so that I can challenge.
How?
That is that is with the deepest respect, my lord. I talked to the register personally, but still I could not persuade him.
Very. When the probate was granted,
The probate admission was granted on 21st September 23.
Which page?
My lord, I have stated in page, my lord, if your lordship takes page 2, paragraph 2.
17th November.
Lord, 17th November, I received the, my lord, the certificate, my lord, letter of
administration.
That was received on 17th November 23. Thereafter, my lord, I had went to the banks and the mutual fund offices, and from there it was, there some difficulty was there on their part. Lord, at paragraph, my lord, 4, my lord, I have stated that.
So appearing for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for extension of time to file inventory and accounts in terms of the order passed by this court by granting letters of administration to the petitioner. Counsel for the petitioner submit that this court by an order dated 17 November 2023, the letters of administration was granted to the petitioner, but due to non-availability of non-availability of total accounts of the deceased, the petitioner could not file the inventory and accounts within the specified period of time in terms of the letters of administration granted on 17th of November 2023. Consider the submission made by the counsel for the petitioner. Prayer and time to file inventory and account is extended for a period of 2 weeks.
Lord, so I have it ready, my lord.
Period of 2 weeks from date. GA number 76 display.
The next matter is similar. Lord, only the deceased is the father and the another is the mother.
Same got the 2 weeks, huh? Disposed of.
I'm grateful, my lord.
My application, my lord. This is the application of the GA.
Yes.
G1 for direction for
publication of citation in a daily newspaper.
Why?
My lord, an order has been passed by His Lordship on 30th August 2024. My application answer C6 page 6 J application. It was directed for the issue of special
It's a
citation.
citation, general citation.
General citation. As per the direction, the notice has been served or the along with the application to the concerning legal years. But one Mr. Ashim Shah had shown that it is refused, it is insufficient of address. And
that report you are not enclosed here. That report you are not enclosed along with this application.
No. It is submitted by the department, Sheriff.
So you could have been enclosed that. Where is your PLA? How many legal layers?
4 legal years are there.
None has come forward.
No, my lord.
None has come forward.
No.
So notices were issued.
Yes, my lord.
Citations have been issued.
Yes, my lord.
Asim Shaw, Anima Shaw, Amita Bhattacharya, Arpita. Asim Shaw on 18th number. On 19th number, one undelivered packet with the postal remark insufficient address in respect of the cited party number 1 Asim. 18th number, one undelivered packet of the postal remark refused. 18 number undelivered packet refused with respect of the party number 3 Amita. Amita is refused. That is a good service.
Yes, ma'am.
Neither the postal electronic packets of the party number 2 and 4, though the general post office till date. However, location item delivered. So only with regard to the 1.
Yes, ma'am. I am paying for the direction for.
That is Asim Shaw.
Yes, ma'am.
Asim Shaw. So what do you want now?
Direction for a paper publication in a daily news.
What is the address?
Address of the
Calcutta here.
Yes, my lord.
Since appearing for the petitioner. The petitioner has filed the present application being J1 of 2025, praying for allowing the petitioner for publication of the citation in the English and general Bangla or Hindi?
Bengali.
English and Bangla newspaper.
And English. Bengali and English.
Bengali and English.
Yes,
Bangla and English newspaper for the purpose of information of one of the legal heirs, namely Asim Shaw. He submits that by an order dated 30th January 2024, this court has allowed the petitioner for issuance of a special and general citation. Accordingly, the petitioner has taken appropriate steps for issuance of a special and general citation. After the issuance of the special and general citation, the Deputy Sheriff of Calcutta had submitted a report dated 16 December 2024, wherein it reveals that the notice sent to Sri Asim Shaw was written unserved with the remark insufficient fund and insufficient address. Accordingly, he prays for publication of the notice in the English daily newspaper. Which newspaper?
My lord, Bengali and English.
Which English newspaper? Times of India?
As we say, my lord, yes, my Times of India
and
Vartaman.
In view of the above, the petitioner is granted leave to publish the notice of the case in the English newspaper, the Times of India and Vartaman within a period of 2 weeks from date. GA number 77 disport.
Much obliged. Application date.
Yes. 68. GA1. What is the application? Leaving granted, removal of paragraph 5 of the none appears not
My
to
lord, I am appearing for my lord. I am appearing in this matter, my lord. Praying for 2 weeks time, my lord.
so and so appearing for the petitioner as per the prayer made by the counsel for the petitioner. The case is adjourned. Let the matter appear on 16th April 2025.
Much
Next.
obliged. Much.
Lordship, I am appearing for the petitioner. I am led by Mr. Priyabrata Thakur in virtual mode. Your
Yes.
Lordship, I am appearing on behalf of the petitioner. This is an application for amendment of the original application for grant. What happened, Lordship, in the original application, the executor made all the necessary heirs, name of the revealed all the name of the necessary heirs, but did not find the address of them. The main petition, Lordship, there was no prayer for special citation in the name of the legal heirs. As such, Lordship, this application is drawn up, and Lordship, in Annexure E, page 35, I have just prayed for such amendment, so properly that matter can be proceeded with, Lordship.
Annexure E.
Yes,
Yes,
specifically the
Lordship.
number 39, if your lordship
Page
comes.
39.
Yes, your lordship. We have indicated the corrections that needs to be made.
This is the only.
Yes, your lordship. In the prayer portion, the amendment needs to be carried out.
And also in Lordship, in page 37, a spelling mistake is there, Lordship.
Yeah.
In page 37, a spelling mistake is there. Assessed.
36, not 37.
37. Yeah.
37. But these are the two corrections.
These are the two corrections.
So and so appearing for the petitioner. Petitioner has filed the present application being GA1 of 2025, praying for amendment in the probate application.
Yes, your lordship. Granted.
In the probate application being PLA number 363 of 2023. Consider the submission made by the counsel for the petitioner. Peruse the proposed amendment. This court find that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Accordingly, the proposed amendment as annexed in the Annexure E of the present application is allowed. Full stop. Consider the submission made by the counsel for the petitioner. Prayer A. Prayer A, B, and C of the present of the master summon is allowed. GA1 is disposed of.
Grateful, your lordship.
My application for amendment in an uncontested probate application. If my lord kindly sees the cause title, the address of the deceased, this was the address in his Aadhaar card.
Soliganj and also at AD number 15,
yes.
Salt Lake City.
The reason being is, my lord, page 21, the death certificate records this Salt Lake address, which is the residence of his son, where he was residing at the time of his demise.
Where is the death certificate?
Page 21.
21 of this application?
Yes, my lord. AD 15.
Yes.
So, department has pointed out this defect, my lord. This is just son's residence. Son is the petitioner here.
This all silly things you are coming with this application.
The cost title, they, unless an amendment application, department did not permit me to correct. So
it is better the department can issue this probate. Need not to list the matter before the court.
Petition for all the cost papers, wherever the cost title is there, I have to.
So and so appearing for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for amendment in the probate application. Consider the submission made by the counsel for the petitioner. Peruse the proposed amendment. This court find that the proposed amendment is formal in nature. Accordingly, prayer A to C of the master summon is allowed. GA1 is disposed.
I'm good.
Item 71, my lord, I am for the petition, my lord. This is my application, my lord, for publication of notice, my lord. My lord, one of the properties, my lord, outside the, my lord, the original site jurisdiction of this honorable
So
court.
you're not paid in the original player?
My lord, original player is there, my lord.
In the
No,
PL, PLA you're not made
no,
a player?
the
You want-
subsequent, my lord, your lordship order, my lord, I have made this application, my lord.
Subsequent to the order passed by this court, you have made an application.
My lord, order
For
dated-
publication?
For
Where
publication.
is the affidavit of assets? Which property?
But the affidavit asset, my lord. My lord, the Coimbatore, property of Coimbatore.
Outside the jurisdiction of the West Bengal?
Outside the jurisdiction of this one.
Where it is?
But
Where
page
it-
number 4, my lord,
Page
serial
number 4 of?
page number 4, serial number 8. my
Of
lord.
the PLA?
In affidavit of assets.
Affidavit of assets. Page number 4.
My lord, page number 4. Serial number 8, my lord, top.
Immovable property
Property.
consisting of piece and for flat number
Flat number 1800 square feet at
garage,
Coimbatore.
Bhagesarulu Road, West RS-Puram, Coimbatore.
Coimbatore.
That's only one.
One property.
English newspaper?
English
Or the
newspaper?
district judge?
No, my lord. In English, one in, my lord, I have made clear, my lord. If my lord may kindly check, my lord, page 6 of my application. One in Hindu, the Hindu, English daily newspaper, and the vernacular daily newspaper, Tanti, a Tamil daily newspaper.
Tanti?
Tanti.
Tanti is the Tamil.
My lord.
So-and-so appearing for the petitioner. The petitioner has filed the present application being GA 1 of 2025, praying for publication of notice in the English daily newspaper, namely the Hindu, and Tamil newspaper, Tanti, T-H-A-N-T-H-I, Tanti, Tanti, at Tamil Nadu, Coimbatore, Tamil Nadu, as one of the immovable property situated at Coimbatore. Consider the submission made by the counsel for the petitioner, peruse the application. This court find that one of the properties situated at Coimbatore. Accordingly, the petitioner is allowed to publish the notice of this case with respect of the property situated at Coimbatore in the English daily newspaper, the Hindu, and the Tamil newspaper, Tanti, which is widely circulated at Coimbatore, Tamil Nadu, within a period of 3 weeks from date.
But a department
number so disposed.
One thing, the department may be directed to serve the
The
provide
department
text
is
of the
directed
notice.
to provide the format of the notice to be published in the said newspaper within 2 weeks from date.
Great.
ऊपर 4 weeks करो. 4 weeks, 2 weeks. ऊपर 4 weeks से 2 weeks.
So item number 72 is my application, my lord.
70?
Praying for 72, my lord. Praying for condonation of delay, my lord, in filing my caveat and affidavit in support of the caveat.
Who is
my
for
lord.
the other side?
My lord, I have filed it but not sought the delay condonation, my lord. I have filed it without the delay condonation, my lord.
So what is the GA1?
That is the GA1, my lord. For condonation for acceptance of my caveat and affidavit.
Condoning the delay, this
Condoning the
GA1
delay,
is
my lord.
there.
Yes, my lord.
Correct. How many days?
My lord, days, my lord, it's
When you
80
receive the notice?
Notice, my lord, I received on, my lord, 26th of September 2024.
Correct.
I filed it on 17th of January 2025. There is an 86 days delay, my lord.
25.
25, my lord.
Whereas item number 72, Mr. Kaushik Pradhan is appearing for the
Who?
Kaushik Pradhan.
Kaushik Pradhan.
Whether he has not come to court. His clerk has told me to seek an adjournment.
Tomorrow? Tomorrow?
Kalke thakbe?
Not today.
Yes,
Come tomorrow. So, not today.
I for the petition, my lord.
73 will I am for the caveat.
My application, my lord, after filing the Probate application, my lord, they have appeared, my lord, and file a caveat and also file an
What?
My lord, they have filed
You are appearing for?
petitioner, my lord.
You are for the petitioner?
Yes, my lord.
Who has filed the GA1?
GA1 I filed, my lord.
For what?
For treating this
Contentious cause?
yes, my lord.
They filed the caveat?
Yes, madam. We have filed caveat and the affidavit
Also-
in support of the caveat
Caveat
also. And serve the copy.
This is a waste of time. Once the department found that the caveat is filed, automatically it has to be testamentary. So appearing for the petitioner, so appearing for the caveator or caveatrix?
Caveator, my lord.
Caveator. It's police. The counsel for the petitioner submit that the caveator has filed a caveat along with the affidavit in support of caveat. Accordingly, the department may be directed to, the matter is to be treated as contentious cause, and testamentary suit number is to be allotted. In view of the submission made by the counsel for the parties, the department is directed to assign the testamentary number and to place the matter before this court on 17th of April 20.
And also, the plain be treated as the petition be treated as a plain, and
full stop. The PLA application be treated as a plaint, and the affidavit in support of caveat shall be treated as written statement.
I'm the objection.
My lord, this is my application. My lord, this is amendment application. At the time of filing the affidavit of asset, my lord, the property has not described properly in my affidavit of assets. So, my lord, there was a direction to take steps accordingly. My lord, we have taken out this application to amend my affidavit of assets.
Affidavit of assets of the main application. Probate not granted.
Oh, my lord, it is a non-contentious probate matter.
What are the affidavit? What are the assets you have included? Where is that?
My lord, assets has been included,
Ah.
but description has not been given properly.
Where is that?
My lord,
Where is the proposed amendment?
paragraph number 3, my lord.
Of page? No.
Number 5.
Proposed amendment.
In affidavit of asset,
Where is that proposed amendment?
in my affidavit of asset, my lord,
Page 70.
6B. Yes.
Page
ma'am.
70.
Yes.
That's only.
Yes. ma'am. From 6B.
What do you want? All the piece and parcel of Vastu land measuring 3 kota, 1 chatak, 3 square meter, along with structure standing thereon, measuring so and so, under the police station, Chinchura, Hooghly. So what why in the district and
Earlier, all that piece and parcel Vastu land measuring about 3 katas, 1 chatak, 33 square feet, along with the structure standing thereon, measuring about 794.
correct?
Lying and situated such and such.
Correct.
In my amendment, my lord.
You want this why?
No, my lord. 16 annas.
Ah.
In the Bengali will, my lord was pointed out that has not been mentioned in my asset. 16 annas, more or less 0.050 acres, more or less. That was the mistake, my lord.
So why the district and session sub-registry office Hooghly? This is under that.
It is.
In the district. So appearing for the petitioner. The petitioner has filed the present application being GA1 of 2025, praying for amendment in the affidavit of assets. By affidavit of assets. Consider the submission made by the counsel for the petitioner. Peruse the proposed amendment. This court find that the proposed amendment as sought from the petitioner is formal in nature and will not change the nature and character of the original probate application. Accordingly, prayer A to D of the master summon is allowed. GA1 is disposed of.
Grateful, my lord.
I'm for the caveator respondent.
Shiva, I'm for the petition.
Yes,
I'm for the petition.
you are for the
For the caveator respondent, my lord.
what application?
This was for discharge of caveat by them, my lord.
They have filed.
They-
You have
they
filed.
Yes, my
So
lord.
you filed affidavit.
No, may I seek liberty to file an affidavit?
You will file affidavit.
My lord, the caveator is not a legal heir of the
Okay, you
testator.
have to file the affidavit.
My lord, they have already filed an opposition.
Filed?
Yes, my lord.
Filed an opposition to this application.
No, not for this application. For the affidavit in support of the caveat. But
affidavit
since
is
the
support of
caveator doesn't have any caveatable interest,
But, I am covered by a judgment of this Honorable Court, a division bench judgment, which says that even if I'm not a not a direct legal heir of the deceased, but if I otherwise have interest in the
Caveatable
property,
interest you have to show on.
my lord. But if
What
I,
caveatable interest? Who are you?
but my lord, I am the nephew of the deceased, my lord. The deceased did not have a son, but has a half brother. My father died before the death of the deceased. The half brother, it was argued that the half brother has better title than that of me. But the only thing, if I can show by way of an affidavit, that I have interest to the property, even if I am not a legal heir, and if I have interest to the property, probably I have caveatable interest.
They cannot go beyond what they have
Okay, want
pleaded
to
in
file
their.
affidavit letter?
But they have already filed an affidavit in support of caveat.
No, with
But that
regard
is
to
a
your
written statement, my lord.
application, your application GA1 you filed.
Yes, my lord. But they
Discharge
cannot
of
go
caveat.
beyond what is there
Correct.
in their affidavit in
If
support
it
of
is go
caveat.
beyond also, the court has to see. So appearing for the petitioner, so appearing for the caveator. Caveator or caveatrix?
Caveator, man.
Caveator, counsel for the petitioner has filed an application being GA1 of
Just delay, my lord.
2025 for discharge of caveat. Counsel for the caveator, press for time to file affidavit in opposition. Let affidavit in opposition filed within 1 week. Within 1 week, reply if any there to be filed within a week thereafter. Please the matter on 17th of April.
Grateful, my lord. 17. Lord, can it be, my lord, after 21st, my lord? Only, my lord.
Then 23rd April.
23rd April, my lord. Grateful, my lord.
I'm appealing for the respondent, my lord, the controller.
Your Lordship, the senior counsel is on VC.
Yes. Who is for the petitioner?
Let's I appear for the petitioner online. I seek my lord's humble permission to appear online. Let's.
Yes.
Please, my lords, we are on rejoinder.
Yes.
If I could just take 5 minutes and perhaps refresh my lord's memory on the nature of the matter before I quickly proceed to the rejoinder minutes. May I? So this was a decision of the Patent Office where my application over a particular form of cigarette has been rejected on grounds of Section 3B of the Patent Act. Whereas the Patent Office has held in my favor with respect to the question of inventive step. So if my lords were to take a look at the impugned decision, can I just do the impugned decision for a moment? It's a very short one. Order, yes. Kindly come to page number 133 minutes. I'm so sorry. If my lords could come to page number 26 onwards, which contains the decision.
Yes.
And in this, my lords, if my lords were to come to the relevant portion where the Patent Office has held at page number 30, could my lords come to page number 30 of the paper book, which contains the relevant portion of the decision?
Yes.
Please see the paragraph in between which starts with, thus none of the prior art, I'm so sorry. Page number 30, second paragraph. It
Yes.
says, thus none of the prior art discloses aerosol generation using salt of nicotine and acid and delivered to lungs through a device. Therefore, from the above discussion, the Patent Office concludes that with respect to the prior art disclosure size, it is not obvious and routine experimentation for a person skilled in the art. And please underscore the line, and inventive step for claims 1 to 12 is acknowledged. Therefore, the Patent Office accepts and acknowledges that my invention has an inventive step. So on the merits of it, there is no problem. And what is the invention? It's a very simple thing. It is a cigarette, one which has salt of nicotine in one channel, pyruvic acid in another channel. When they combine, it gives birth to an aerosol. That's it.
Correct.
That's the simple issue there. Please, minute. Then my lords may come to, sorry, you're right. It's not a cigarette, it's a device. This can be used for non-cigarette related applications as well. That's important. Please, minutes. So the invention is capable of being used for delivery mechanisms for other aerosols also. Its application is not limited to cigarettes alone, minutes. That is the crucial fact of it. Because if my lords were to take a look at the claim, nowhere does it say that its application is limited to cigarettes. Now, the challenged portion of the decision, my lords, is at the second portion of page number 30, which is the observation under Section 3B.
Correct.
Now, in this, there are only two aspects. Please, minutes. On this, there are two aspects of challenge. First is that the bulk of the documents which have been cited in the final order were never shown to us in the hearing notice. And they were not even mentioned in the hearing notice. So on the face of it, I never had an opportunity to deal with these documents during the course of arguments. That's the first limb of the submission. The second limb of the submission is that even otherwise, the ground under Section 3B is inapplicable to the facts of my case. Those are the
Yes.
only two short points
Involved in the matter. Yes.
going to show how the reply of the Patent Office is insufficient. I will only request my lords to come back to the original hearing notice for a moment so that I show how what was cited in the hearing notice is different from what was cited in the final judgment.
Correct.
So can I request my lords to come to the hearing notice, which starts at page number 132, my lords.
Yes.
Page number 132, annexure H. And my lords would see this is the notice dated 1st of May 2023.
Yes.
And in the subject, my lords would see hearing notice in reference of the application number 685 Kolkata 2015.
Yes.
Now here, kindly see, my lords could come to the documents which are cited under the ground of non-patentability under section 3 at the bottom of page 133. My lord
Yes.
sees that? Please
Yes.
see. Without prejudice to any other objections, prima facie it seems that the subject matter of amended claims 1 to 17 of the alleged invention discloses an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. So they've
Correct.
reproduced the language of section 3B.
Correct.
Then, Mela, they're saying, hence the subject matter of the amended claims 1 to 17, as filed in the instant application, prima facie development to a simulated cigarette or e-cigarette. Please note, underscore the words e-cigarette,
Yes.
because mine is not an e-cigarette, it's not an electronic cigarette, which I showed in the last date of hearing.
Yes.
That an electronic cigarette has a separate definition and mine is not an e-cigarette. And allow me to say this, the worst part of this conclusion is their assumption is that the invention can be used exclusively for cigarettes, whereas it is an inhalation device. It can in fact even be used for people with respiratory conditions such as asthma. We have said as much. Therefore, the patent office has proceeded with a prejudice that this device is capable of exclusive use as a cigarette.
Correct.
And please, my lords, then come to the next page at page number 134. I would only request my lords to understand a few dates here. Please see what have they cited here. It starts with the Indian Council of Medical Research has released a paper on 31st of May 2019. My lord sees that?
Yes, yes, yes.
Now,
Because these
please
are the
note,
document which these are the document which the opposite party has argued. They are telling that yes, these are the medical research document which was enclosed with the first hearing notice. So that's why the document has been supplied. This is the main argument which they have made.
correct. In fact, they have said two things. One, that all the documents that they have cited are cited within this document itself. That is one. Second argument that they have said is that in any case, it's a public document. Therefore, there is no need for service.
Correct.
It's a public document.
Correct.
Now, please, these are the only two issues. So therefore, I have to limit the scope of my submission to this first, and then I'll come to 3B. One, please take a look at the title of this 31st of May 2019. It says, vaping could put you on path from womb to tomb. ICR recommends ban on e-cigarettes. Now, this is a newspaper article. It's not a journal article.
Okay.
Let me show the relevant document, the page number. This is not even a journal article. This is a newspaper article. So can I just request the instructing counsel to hand over this document so that my lord sees this? This is a newspaper article. Because the date makes a huge difference here. Please see what has happened here.
Yes.
My lord,
if my lord sees this.
Yes, Mr. Sai.
May I interrupt? Because what I have placed before your lordship is from their petition, their appeal, my lord. I did not supply anything else. I have placed everything from their document, my lord.
Correct, no problem. That's why I stated with regard to, because your contention is that what you have mentioned, if you go by the act and the document, it provide that the document is already supplied. And you are telling that these are the public documents, so need not to supply further. It is available in the public domain.
Yes.
These are the main two submissions which are made.
Yes.
And with regard to the e-cigarette, that is a different thing.
Yes.
These are the two main submissions.
Yes.
So now Mr. Sai has giving the reply to that whether this document is connected with the let me see, then we'll see to that.
One minute, my lord. Another point, my lord. Is it, my lord, the main factor is the main end product is nicotine.
Correct.
Nicotine based aerosol. My lord, nicotine itself is prejudicial to the human being, animal, plant, etc. My lord. So whatever e-cigarettes and everywhere, nicotine is there. So nicotine ends means electronic nicotine delivery system. Nicotine is there.
Okay, you are I take a
Yes.
note of it.
Yes.
Let they give the reply. We'll see. Yes, no problem. Yes.
Please. If my lords has this article, please see.
Yes.
This is the article which is titled "Vaping could put you on path from womb to tomb." This is dated 31st of May 2019.
Yes.
Now, within this article, could my lords come to the second page of this article? Please see the second page of this article. It starts with medical research body. The medical research body published a white paper on end nicotine delivery system on the eve of World No Tobacco Day, the ICMR said use of e-cigarettes adversely affects almost all human body systems with impact across life from womb to tomb. Now, this article, which is within, that is this journal paper, which is within this article, was never supplied. But they cite this in the final decision. So what is actually cited expressly in the hearing notice is this newspaper article dated 31st of May 2019.
Correct.
But the medical research paper on ENDS was cited for the first time in the decision. They did not even cite this at the time of the hearing notice.
Yes.
Now, if I could just request my lords to come to the impugned judgment, the impugned decision, I will show what are the documents. So my lords would see that in the hearing notice, only one document is cited. That's it. That is a newspaper article. Now
Correct.
kindly come to the decision. Now, the decision, page number 34. In fact,
Yes.
please see the decision, page number, I will show you in just a second. My lords could come to page number 30. Page number 30.
Yes.
The impugned decision. Can I just see this, please? Now, here, my lords, in the decision under observation under section 3B, please see the paragraph it starts with, in the hearing notice, in support of section 3B, submitted ICMR white paper on electronic nicotine delivery system attachment 1. Please note, what was cited in the hearing notice was not the ICMR paper, but a news article about the ICMR paper. There's a difference. Then, my lords may then come to the next paragraph. It says, in published ICMR white paper, it is clearly mentioned that nicotine and nicotine sulfate are listed as hazardous chemicals under the Environmental Protection Act of 1986. This argument of Environmental Protection Act was never expressly mentioned in the hearing notice. So therefore, what they are saying is, every issue that is mentioned in the ICMR paper must be treated as being referred to in the hearing notice, even though there is no express reference.
Okay.
So none of these specific grounds are there in the hearing notice.
Yes.
They are saying that I cited a news article. That news article mentions an ICMR paper. That ICMR paper contains a few points with respect to nicotine's hazardous nature. So therefore, all those points must be treated as being part of the hearing notice.
Correct.
I'm sorry to say this is a stretch of an argument. Then kindly see page number 31, the next page. Then my lords will come to the title Indian Perspective at page number 31. Here it says, in India, the use of nicotine as an ingredient in any food item is prohibited under Food Safety Act. This is the next ground. First of all, my invention is not a food item. Second of all, you never cited the Food Safety Act in the hearing notice.
Yes.
As an objection. Then, my lords, please see the next paragraph. It says nicotine and nicotine sulfate are listed as hazardous chemicals under the Environment Protection Act. Again, they're mentioning this for the first time. Then my lords may come to the next paragraph where they're discussing the ICMR white paper in detail. The ICMR white paper has rejected the argument that e-cigarettes could help smokers quit tobacco consumption. So they are citing the ICMR paper and its findings, which was never supplied to me. Then kindly see the paragraph. It says, hence, as per the ICMR white paper, nicotine replacement therapy is a myth and replacement of nicotine consumption with nicotine is not possible. So the central finding under section 3B of the Patent Office is on the strength of an ICMR white paper, which was never supplied to me, period.
Yes.
And second limb of the argument is, all the material cited is in relation to e-cigarettes.
Yes.
I am not an e-cigarette. My invention is not fundamentally even being sold as a cigarette.
Yes.
3, if this is the position of the Patent Office, that non-nicotine related invention can get a patent, they should not be giving patents over conventional cigarettes as well, which use nicotine.
That
Because
already.
the fundamental problem is, exactly. So since there is no ban with respect to conventional cigarettes, to suddenly make nicotine the scapegoat for not granting patents with respect to other devices, I'm sorry to say, is rank violation of Article 14 in the first place. Then, my lords may come to the next paragraph. As per the Government of India, Ministry of Health and Family Welfare. This attachment discloses that electronic cigarettes, the most common prototype, are devices that do not burn or use tobacco leaves, but instead use vaporizer solution, which the user then inhales. Please note that this entire paragraph finds mention for the very first time in the hearing notice again. So the point of the matter is, all the documents cited from page number 30 to 32 were cited in the hearing notice for the very first time. And I had shown my lords the definition of an e-cigarette to take my invention outside the definition of an e-cigarette because it is not an electronic cigarette in any form whatsoever.
Yes.
So, principles of natural justice. Allow me to cite a judgment of the Supreme Court on how is such a decision to be dealt with when an adjudicating authority relies on a document which the party does not have access to during the course of hearing, and which document finds mention for the very first time in the decision as opposed to the hearing notice. So, Miraj, I am citing a judgment of the Supreme Court in Sanyong Engineering versus National Highways. Can I just request the instructing counsel to hand over a copy of the judgment, please?
Yes, got it.
Please, Miraj. Paragraph 73 and 74 of this judgment.
Paragraph
73 and 74, and this, my lords would find at, I'm so sorry. Do it. My lords would find this at internal page 56 and 57, the bottom of internal page 56.
Yes, got it. Yes, continue.
Given these parameters of challenge, let us now examine the arguments of the learned counsel on behalf of the appellant. There can be no doubt that the government guidelines that were referred to and strongly relied upon by the majority award to arrive at the linking factor were never evidence before the tribunal. In fact, the tribunal relies upon the said guidelines by itself and states they are to be found on a certain website. Same argument that this is a public document. The ground that is expressly taken in section 34 by the appellant is as follows. It is pertinent to mention here that no such guidelines of the Ministry of Industrial Development had been filed on record by either of the parties, and therefore the tribunal had no jurisdiction to rely upon the same while deciding the issue before it. Accordingly, the impugned award is liable to be set aside. Please see para 74. The learned counsel for the respondent also agreed that these guidelines were never in fact disclosed in the arbitration proceedings. This being the case, and given the authority cited here and above, it is clear that the appellant would be directly affected as it would otherwise be unable to present its case, not being allowed to comment on the applicability or interpretation of those guidelines. For example, the appellant could have argued without prejudice to the argument that linking is dehorse the contract, that of the three methods for linking, the new series with the old series, either the second or the third method would be preferable. For this reason, the majority award needs to be set aside under section 34(2)(a)(3). Notwithstanding the fact that this judgment was delivered in the context of an arbitral proceeding, the fundamental principle applies even more in the context of an administrative hearing or a quasi-administrative hearing. A patent office hearing under section 14 is a quasi-judicial hearing because it results in the grant or the denial of a right. And it is settled principle that all principles of natural justice equally apply to hearings before the patent office. In the facts of this case, the fact that it is a public document is an insufficient argument because even if it is a public document, the manner in which the document is going to be cited by the patent office should be put to me for me to be able to rebut that contention. I never had the opportunity to present all these distinguishing points, which I'm presenting before this honorable court, before the patent office.
Yes.
So therefore, my lords, my submission is on this ground alone, it can go back. But
yes,
in my view, it appears that the patent office fundamentally has a problem with any nicotine related device. And therefore, this honorable court will need to rule on the issue so that a consistent position can be taken by the patent.
correct.
Otherwise, today this will be this controller, tomorrow it will be some other controller, because each of them will have varying definitions and interpretations of section 3B. So my submission is the principle of natural justice argument in my humble submission has been clearly made out. Let me come to the section 3B argument. On section 3B, their position is, as the counsel for the patent office has captured for our benefit, Please, minutes.
Patent Act.
My lord.
Patents Act.
Yes, sir.
Please, minutes. Before I go to section 3, let me highlight 3 important points for my lords to consider. 1, the Patent Office is not a drug regulator. The Patent Office is not the regulator of the cigarette industry. The Patent Office is not the regulator of nicotine industry. The Patent Office is not a health regulator. It is only in the business of grant or rejection of patents.
Correct.
Because, my lords, even if a patent is granted, I cannot commercialize the product until the law allows it. So the grant of a patent in itself will not result in commercialization of the product, because there are any number of instances where, even with respect to banned substances, people can innovate and they will release their products once the regulatory ecosystem allows it. Is patents are negative rights. Patents do not give me the right to use. They give me the right to stop others from using my invention.
Yes.
So if my lords could take a look at section 48 for a moment of the patent, please see section 48, because this fundamental point on the nature of the patent right has been in the Patent Office itself. So let me show that, my lords. Section 48, my lords.
Yes.
Subject to the other provisions contained in this Act and the conditions specified in section 47, a patent granted shall confer upon the
Patentee
of the patent is a product. Please, my lords, please see where the subject matter of the patent is a product. Please see the next words: the exclusive right to prevent third parties.
Correct.
It is not a positive right; it is a negative right.
Correct.
And if my lord were to take a look at 48B again, even for a process, it is only the right to prevent third parties, which means even if the Patent Office were to grant me a patent on this invention, their apprehension that somehow I will be encouraged to commercialize the product is misplaced. I can't do that. Second, why is this crucial? My lords may come to section 83 of the Patents Act for a moment. There is that provision where it says that even kindly come to section 83 and subclause E.
Yes.
The title of this provision is General Principles Applicable to Working of Patented Inventions. I would request my lords to walk through the provision with me slowly because the language is beautiful. Without prejudice to the other provisions contained in this Act, in exercising the powers conferred by this chapter, this is the compulsory licensing chapter, chapter 16.
Correct.
Regard shall be had to the following considerations only. Kindly come to E. That patents granted do not in any way prohibit central government in taking measures to protect public health, which means even if a patent is granted, the government can prevent the use of the patented invention in the interest of public health.
Correct. Correct. Correct.
That means, citing public health, you don't need to deny the patent itself. You can be granted a patent and you can still be stopped.
The concerned government will take care of it, whether it is a banning or not.
Absolutely.
As per E.
Absolutely, my lords.
The patent granted do not in
Absolutely,
any
my lords.
prohibit. Central government may take the measures. So if we take the
Exactly.
objection of the authorities, it is a nicotine and it cannot be, but they cannot refuse. But if the central government with the concerned authority who prohibit under the Drug Act or
Correct.
whatever, they will take care of it. That is
Exactly, my lords. That is the point. Now, I will do a legal fiction here. I will read 83E in a different way.
Yes.
Now, E could have said that no patent will be granted which affects public health.
Correct.
E could have said that, but he is not saying that. E is actually saying that patents granted can be prohibited. It does not say patents cannot be granted.
And that's negativity is not there. They can
grateful.
go. They can go. That's what I'm telling.
Correct.
The patent
Please,
office cannot say this is like this so that we cannot grant. But they can
Exactly.
grant, and the authority who is the competent authority can prohibit. for using of this.
Absolutely. Absolutely. I'm so grateful. That is the simple submission which my lords has captured brilliantly. That is the subject of the matter. That is the substance of the matter completely.
No,
Now-
Mr. Sai, you are appearing in the matter. Only I want to know in the patents. So like this
Please.
matter. Correct. The
Please.
patent office, you know what is the condition as present in our country.
Please, my lords, please.
So with regard to all this, the nicotine and all other drugs, whether
Please,
this
my lords.
patent office is having a competent officer or competent experts to take the opinion before the grant or before hearing of the controller.
So I'll answer this question. I think it's a brilliant question.
Why I am telling you made the submission. This court, though this court can do that, but this is with regard to the expert opinion. This is with regard to the expert opinion under the IP Act. Under the IP Act, court can take the expert opinion. That is different thing. Now, at the time of hearing by the controller office of the controller, whether the controller have the power to take the opinion of the expert.
Kindly see section 77 of the Patents Act that answers the question. Where the powers under CPC have been given to the controller. Please see section 77. Powers of a civil code to the controller, section 77, chapter 15.
Yes. Controller has a certain power of the civil code.
My lords has it?
Yes. Good.
Exactly, my lords. Now, issuing commissions is under D. That is including for local commission as experts.
Correct.
77D, 1D.
Yes.
And
Issuing
please see
commission
77(1)A. It says summon. Correct.
enforcing independence, requiring discovery and production. Okay.
Please.
D is the issuing on examination of the witness on
Please.
document. Okay.
And the omnibus power under H. H says any other matter which may be prescribed. Why am I saying this? Please, my lords. Assume for a moment that the patent office is dealing with an advanced technology which India is still behind. Okay. Then even the patent office will require expert opinion. Now, please come to section 115 of the Patents Act, which allows the court to appoint experts, scientific advisors. Please see, in any suit for infringement or in any proceeding before a court under this act, the court may at any time, and whether or not an application has been made by any party for that purpose, appoint an independent scientific advisor. Now, what I'm saying is, the reason why that provision is needed for the court is because the court is not as expert a body as the patent office.
Because that is also provided in the IP.
Exactly.
The court can take the expert opinion, and we can make a panel of the experts, and we can take the opinion of that.
Please, Minaj. My point is, this is an inherent power of the patent office.
Correct.
The court could have done this even under CPC under Order 26 without Section 115, but it is specifically provided for. The patent office can do this without a problem. So, on this issue, even on subjects which are way advanced, as a matter of practice, the patent office has engaged experts in the past. It is not new. They have done this. Now, let me come back to the issue in question about nicotine and Section 83E.
Yes.
I would request my lords to read Section 3B, which has been cited against us, along with 83E for a moment, juxtapose both these provisions, and I'll explain what their problem is. Does my lords have Section 3B?
Yes.
Kindly take a look at the chapter for a moment, chapter 2. The title of the chapter is Inventions Not Patentable.
Correct.
Then the provision goes on to say what are not inventions. Then it says the following are not inventions within the meaning of this act. I will just explain the consequence of this for a moment. Section 3 means I can't even sit for an examination. It does not talk about the passing mark for an examination. If I'm a candidate for an examination, exactly, they're saying you can't even appear. Such subject matter can't even be considered whatsoever. Okay. Now, kindly see Section 3B. An invention, the primary, now please mark the words, the primary or intended use or commercial exploitation. the primary or intended use or commercial exploitation of which would be contrary to public order, morality, or health. So my primary goal must be to affect health in an adverse fashion.
Correct.
It can't be an incidental goal. It can't be a secondary effect. Now, going by the logic of the patent office, no alcohol related preparation can get a patent. No nicotine related product can get a patent even if it's a conventional cigarette. Manufacturers of guns cannot apply for patents. Manufacturers of knives cannot apply for patents. All defense inventions will be affected by this. The point is, primary or intended use should mean that its express purpose must be to aid mischief. Its express purpose must be to cause harm. But when you read this with 83E, it says, grant a patent, what it does to public health will be decided by the central government. Now, with 83E being present, the patent office is saying, I will take a decision whether or not a patent can be granted on this particular subject matter. Now here, their entire interpretation of section 83E, sorry, section 3B is completely contrary. 3B is contrary to TRIPS as well as Paris Convention, and I'll show this, Milans. Let me show first Paris Convention, which is the ancestor in terms of TRIPS, which is the earliest instrument. Please see Paris Convention. Can I request the briefing council to?
Yes, got it.
Please see Article 4 Quater. Please see the title of the provision.
Yes.
Patentability in case of restrictions of sale by law. My lord sees that?
Where?
Patentability in case of restrictions of sale by law. Bottom of, it says Article 4 Quater, page number 7 at the bottom, my lords. Article 4 Quater at the bottom of the page. It should say 4 TER.
Yes.
4 QAE TER.
Correct. Yes.
Please, my lords. Under the subject of patents, it says patentability. Please see the title itself. Patentability in case of restrictions of sale by law. So where commercial exploitation is prohibited, what can you do with respect to patents? That is the issue. Now kindly see the subject. The grant of a patent shall not be refused, and the patent shall not be invalidated, that is after granted, on the ground that the sale of the patented product or of a product obtained by means of a patented process
is subject
to restrictions or limitations resulting from domestic law. Which means the commercial sale may be banned, but you can't use that as a ground to refuse a patent. The reason is commercial exploitation is within the domain of regulatory approval.
Correct.
Patents are a different basket altogether.
Correct.
Therefore, what the patent office has done today, citing Article 3B, is in direct violation of Article 4 Quater, and India is a signatory to Paris Convention. The patent office is not the arbiter or adjudicator of public health. They need to understand this.
Yes.
And their entire decision proceeds on the basis that my cigarette is or my device is a cigarette and it's an e-cigarette, both. Both of them are faulty. Now my lords may come to Article 27 of TRIPS, which repeats the very same issue in an elaborate fashion. Article 27 of TRIPS. Does my lords have it?
Yeah, just a minute.
Please,
yes, got it.
Under section 5, under the heading patents, Article 27, please see the title, patentable subject matter.
Correct.
I would request my lords to read both subarticle 1 and subarticle 2 along with me. Subject to the provisions of paragraphs 2 and 3, that is of this article, patents shall be available for any invention, whether products or processes, please underscore the words, in all fields of technology, provided that they are new, involve an inventive step, and capable of industrial application, subject to paragraph 4 of Article 65, para 8 of Article 70, and para 3 of this article. Patents shall be available and patent rights enjoyable without discrimination
as to the place of invention.
place of invention, field of technology, and whether products are imported or locally produced. Then, my lords may come to sub-article 2.
Members may exclude.
Members may exclude from patentability inventions. And my lords, member means the government, not the patent office.
Correct.
Member means the signing government, the state itself, not the patent office. Members may exclude from patentability the prevention within their territory of commercial exploitation of which is necessary to protect order public, that is public order and morality, including to protect human, animal, plant life, and so on and so forth. Please see the last line, provided that such exclusion is not made merely because exploitation is prohibited by their law. Which means the patent office will not prevent grant of a patent merely because commercial exploitation is prohibited by law.
So,
Because the word exploitation comes, please.
Under the proviso, they cannot. Under the proviso clause.
Exactly. So under the proviso, it means that they cannot reject patents citing commercial ban. And when they say exploitation, please see the second line of Article 2. Exploitation means commercial exploitation, because that is the word used there, commercial exploitation.
Yes.
So, provided that such exclusion is not made merely because the exploitation is prohibited by their law. So, they are in violation of Article 27(1) and 2.
Yes.
And a decision to not grant patent for a species of articles must be taken by the state or the parliament, not the patent office. And on this, I'll give an example from section 3 itself. Kindly see section 3D for a moment.
Yes.
Under section 3D, which is to prevent pharmaceutical evergreening, please see what the parliament has said. This was introduced in 2005 when India opened its market for pharmaceutical patents and chemical patents, product patents. The mere discovery of a new form of a known substance, which does not result in the enhancement of the known efficacy of that substance. So this is prohibited. That is, this will not be treated as an invention. Why? That means if there is a chemical A and you develop a salt of A, you will not get a patent over salt of A if it does not show better efficacy than the salt itself or A itself. So please see the explanation. For the purposes of this clause, salts, esters, ethers, polymorphs, all or so and other derivatives of the known substance shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. So where the parliament wants a higher bar, it has said as much for a particular species of products. The patent office cannot take this decision. So under 27(1) of under 27(1) of TRIPS,
yes,
it is for the government and the parliament to ban patents on cigarettes. It has not done so. It has not banned the patents on e-cigarettes or any form of cigarettes for that matter. So today, the decision of the patent office is contrary to 83E, is a misreading of 3B, is a violation of Article 4 Quater of Paris Convention and Article 27(1) and 27(2) of TRIPS. Apart from misrepresenting my device as an e-cigarette when it is not even a cigarette in the first place. Now, final contention. Their point was, since it can be used for, let's say, consumption of nicotine, the amount of nicotine which my product can deliver in one go apparently is more than what is permitted by the law. I repeat, that is for the regulatory approval, not for you.
Okay.
If the amount of consumption of nicotine from my product exceeds the permissible limit, then that is for the government to look into, not you.
Correct.
So every point of decision in this impugned judgment of the patent office steps into the territory of the industry regulator, but not the patent office.
Okay.
And if this clarity is not given to the patent office, my lords, one controller says it is possible, another controller says it is not possible. On a regular basis, we are being hit by Section 3B by people who are not understanding what is the purpose of the patent office. The patent office has now become the regulator of the cigarette industry, which it has no business doing.
Yes.
And the position that they're taking, pardon me for saying so, is fundamentally hypocritical because they don't have a problem with nicotine when it comes to conventional cigarettes, but they have a problem with nicotine because e-cigarettes are banned. Nicotine is bad either ways. So, my lords, I really have nothing further to submit. Let me just take 10 seconds to confer with my briefing counsel if I missed out at a point. Just give me 10 seconds.
Correct.
My briefing counsel wants me to cite Article 14 of the Constitution. I don't want to push this into a constitutional argument beyond this. All I want to say is their behavior is arbitrary, and therefore the arbitrary behavior has to be put to rest by this honorable court. Otherwise, this is a clear violation of Article 14. Because
Yes.
my lords has already given enough time to this matter. I don't wish to take my lords' patience for granted.
Thank you. Thank you.
I'm grateful for this indulgence through virtual hearing. My
Thank
sincere
you.
apologies. Grateful, deeply obliged. Plus, we'll file written submissions within 2 weeks, subject matter, or 1 week.
I will give the time for the written submission. No problem.
Grateful. Deeply
My lord,
obliged.
I shall file a written submission.
No problem.
But before that, my lord, my learned friend has said that all the acts and everything, I never discussed this thing before in the hearing notice or elsewhere. But for the first time in the order, I have mentioned all those things. But kindly see their, kindly come to their appeal first. In the appeal, they listed, my lord. Page 7, paragraph H.
Page 7.
Paragraph H.
Paragraph H, yes.
Yes. First of all, my lord, kindly see, ICMR report has been mentioned in the hearing notice. ICMR report is annexed with the appeal, my lord. So the question of not supplying the same is not correct, my lord. My lord, now kindly come. ICMR white paper on electronic nicotine delivery system dated May 29, 2019. My lord, kindly
So sorry, I don't wish to interrupt because I need to leave. Can I just take 10 seconds and I leave after that, Miller? Just 10 seconds. My point was they attached one document and they're saying all that is referred in the document should be referred to in the notice. That's the limited point. That can't happen. They have to cite everything specific.
That's why
Great.
on the last occasion, I also put the same question to him.
I am so grateful. Exactly, Miller. I'm so grateful.
Page 34. Kindly see
page 34.
White paper on electronic nicotine delivery system, which they have listed, my lord, here that those were not supplied to them. But here, my lord, page 34, it was supplied.
Supplied?
Supplied, my lord. ICMR report was supplied, my lord. Because in the hearing notice, it has been mentioned, my lord. Kindly
come to 132. One 133 last paragraph.
My lord, what I have said, my lord, I'm sorry, my lord. What I have said that those were available in the website.
Correct.
Yes,
That's
were available in the website, not supplied. Those were available in the website. They could have found that thing from the website, my lord. That I have.
Yes.
My submission was that.
Correct.
I apologize for. My lord, kindly see.
No, that's why they have made the submission. Now, Mr. Sai has also made the submission. Suppose I am the plaintiff and you are the defendant. I made a case, filed a suit, made an averment. Yes, this is the violation, and this violation is so and so, so and so. If I have not explained that, and the copy is not served to you, can you say yes?
My lord, ICMR report, everything's are there. Everything. If I place the ICMR report, my lord, then your lordship will get this thing. My lord, kindly see ICMR report at page 34.
34. Yes.
See, these are all there. They mention about the statutes and everything. Why nicotine is prejudicial? It is also mentioned over here. My lord, and your lordship will find from page 44, 46, my lord. Then kindly come to page 48, my lord, see.
Yes.
The Indian Council of Medical Research has warned of a potential public health disaster if action was not taken to completely prohibit and dissuade the
So that's why, if
the
it is prohibit, can you prohibit? Or you are the authority to prohibit?
My lord, I am the patent office.
You are,
I
you
cannot
are the
prohibit it.
Ah.
I am the patent office.
Ah.
If a patent is applied
Hmm.
and if it is not fall under section 3B, my
Correct.
lord, I have no other alternative but to reject it.
So
My lord,
that's
there are several judgments of the Honorable Supreme Court that if a statute empowers the authority to do something in a certain way, that has to be done in that way, otherwise not, my lord.
Okay.
Here the statute is saying section 3B. How can I deviate from that?
Okay.
How can I say that it is not applicable when I find from the articles that it is prejudicial to the health? So,
Yes.
my lord, my learned friend has submitted
Yes.
that my learned friend has submitted that an expert body is required to understand the whole thing. My lord, how the patent office has decided this case? They decided this case on the basis of the statute, on the basis of the basis of the Drugs and Cosmetics Act 1940. My lord, I have placed that section. My lord, when the minimum quantity is 2 milligram, but here it is 270 milligrams or like that. My lord, it cannot be permissible. So on that basis, the patent office has come to the conclusion that it is prejudicial. Yeah. And the dictionary meaning of the nicotine is that it is addictive and poisonous chemical. Addictive and poisonous chemical, my lord. And if I am the adjudicator, if I know all those things, how can I deviate from that? How can I pass an order? How can I pass an order, my lord, avoiding or ignoring all those things, my lord?
Okay. Next. Okay.
Judgment will just because something other patent officers found, I don't have to follow that. There are many cases where the patent has been granted.
Yes, my lord, I have already submitted that. Here, my lord, my learned friend has cited some other cases where the patent has been granted, my lord. They are saying that is a similar case. My lord, in that point,
Many cases have not been granted. Philip Morris.
on that point, my lord, my lord, I have cited some cases, my lord, Supreme Court cases.
That I have taken note of.
It is
That
a
I have
settled
taken.
legal proposition.
Whatever the judgment you cited, I have taken note of it.
yes.
No problem.
So Philip Morris, same nicotine.
In addition, what Mr. Deepak Sai has now,
Yes,
Sai
my lord,
Deepak has
Mr. my lord,
submitted
my
is any reply? which
yes,
you
my
can
lord,
give.
my learned friend has said that it is not mentioned earlier. My lord, what I have said that it is in the website and the ICMR report in the website. In the ICMR report, all the statutes are mentioned. And my lord, I can show your lordship from the ICMR report that whatever my learned friend has said that those were not supplied to them, they could have easily got it from the website, government website. My lord, and my lord, kindly allow me to submit a written submission.
That's all?
Yes.
Thank you.
Grateful, my lord. So deeply obliged.
There is a Delhi High Court judgment where it is saying that
Philip Morris.
Philip Morris. I will annex it with the
The son suffering for the petitioner.
My lord, there also nicotine was
Okay,
not
okay.
allowed.
You do give all the things and written notes of argument. So and so suffering for the petitioner. So and suffering for the respondent. Full stop. Hearing concluded. Full stop. The parties are directed to submit their written notes of argument. How soon? 10 days. 2 weeks. Within 2 weeks.
2 weeks, minutes.
Is the matter. आज कितना तारीख है? 26.
26 March. Please.
Let the matter appear on 10th of April 2025 under the heading to be mentioned for filing only written notes of argument.
So grateful, so deeply obliged. Grateful. It's been a pleasure and an honor appearing before my lords. Grateful.
Thanks. Yeah.
Thank you.
Still, no, instead of 10th, 11th.
My lord, 11th, I have a matter, my lord. I have matter fixed on it.
Filing written notes.
My lord,
So when? Because 8, 9, then
My
8,
lord,
Then the 14 to total 18, it is holiday. But 16, 17 is the non.
9th, 10th, up to 10th.
8, 9, 10 bit. 8, it can be.
8.
8.
Yes, Your Honor.
8 is Tuesday. It is correct. It is 8. Has to be mentioned for written filing return notes of argument by both the parties. Item number?
Please, Your Lordship, Lord, I'm appearing for the defendant in the matter.
For attachment before judgment, Milord.
Yes.
I've already concluded my submissions. In a suit for recovery of money lent and advance, Milord, Mr. Bagh, learned advocate, Milord, was making his submission.
Yes.
But may I only pray, my lord, if the matter is fixed on any date, my lord, will come back because I am told that there's a 3 o'clock fixed matter before your lordship. My lord, will come back on any day, my lord. I've made my submissions on the last day.
I think 3 p.m. matter will not be taken. Continue with.
My lord, may I only indicate why I'm making that prayer? I've made my submissions, my lord. Submissions are over. I just need to show the judgments. I'm not really ready with all the judgments. So I'll be wasting your lordship's time. I don't want to do that. Any day that suits your lordship, my lord, I'll come back. I'll only indicate the judgments and I'll wrap the submissions, my lord.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the defendant prays for time to rely some judgment. Accordingly, case is adjourned. Let the matter appear on 9th April.
9th April.
Lord, may I only request that it retains its position so that it can be continued?
Yes, it is.
Deeply obliged.
I'm deeply obliged.
Yes. Next.
I pay for the respondent number 4 bank account. In this matter, Mr. Banerjee has concluded his argument on GA2, my lord. The plaintiff has to give reply.
Who is for the plaintiff?
Mr. Lordship, we are being led by Mr. Rupa Ghosh, but he is in courtroom number 40, Your Lordship. So I'm praying for a short accommodation. If you can just grant me a passover for a short while. If you can just grant me a short passover till the council is here, Your Lordship.
Not today.
My lord, kindly make retain his position because bank is suffering.
It will be.
Milord, for the plaintiff, Milord, this is a GA, Milord, filed by the defendant under Order 7 Rule 11, Lordship. Milord, their submission was over. We are to reply. Milord, I am, Milord, led by Mr. Kankani, Milord. He has some difficulties in his family, Milord. So, Milord,
tomorrow?
If your Lordship kindly makes it not this week, Lordship.
You are for the plaintiff.
I am for the plaintiff.
So appearing for the plaintiff, none appears on behalf of the defendant. As per the prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 17th April.
Item number 20.
सब पाठड़ में है 20 ये पाठड़ क्यों रखे हैं ऑर्डर में तो पाठड़ नहीं है पाठड़ है none appears on behalf of either of the parties none appears on behalf of either of the parties no accommodation is sought for the interest of justice the case is adjourned. Let the matter appear on 24th of April. Next. Same order. 24th April.
Number 22.
May it please your Lordship, Milord. This is my application. And it would come back to your Lordship that, Milord, this was a suit filed, Milord, for anti-suit injunction in relation to, Milord, a matrimonial dispute. The issue raised by the plaintiff, Milord, was that the power of attorney through which my client who is staying in California had empowered, my lord, his relative was not, my lord, sufficiently stamped. Now that defect has been cured. May I, my lord, most humbly beseech your lordship for a short passover, because my learned advocate on record, my lord, intends to file that apostolate document.
Who is for the plaintiff?
My lord,
Every day they are mentioning when the matter is called, they are not appearing. Every day they are mentioning. Just day before yesterday also they mentioned matter.
my lord, may I please beseech your lordship for a short passover, because my lord, we are
Passover,
suffering.
then I 3 p.m. matter.
No, since the 3 p.m. matter your lordship indicated may not
Can
be
I,
taken.
can I, so can I call them quickly?
My lord, may I kind, my lord, beseech your lordship for a short passover, my lord.
Is it?
File that, my lord, the
Passover.
cured document.
Passover. Yes, next.
My lord, my application.
Yes.
My lord, this is a suit for defamation, my lord. GA1 is my application for injunction, my lord. I'm enjoying an interim order. GA2, my lord, the respondent has filed an application for vacating of it. Now, my lord had given them liberty to, my lord remembers this is a matter in relation to which, my lord, there are two premises number in Robinson Street, 2 Robinson Street and 3 Robinson Street. The respondent went ahead and filed a suit in the city civil court, my lord, in respect of.
What has happened to that suit?
My lord, nothing has happened. That
Amendment allowed?
amendment application is still pending, my lord. My lord had given them liberty in the order, my lord, to apply for vacating or modification of the order if an order is achieved in the modification application. My lord, nothing has been done till date. They have filed a huge, my lord, GA2, my lord, putting in all records of the suit, my lord, as if the suit is being heard here. But, my lord, I would only pray, my lord, since they are not here today, my lord, this injunction, my application, my lord, if my lord takes up. My lord remembers the details, but very briefly. My lord, the defamatory content, my lord, is at page 51 of my application.
Yes.
Page 51, my lord sees there are two things in this a screenshot of a WhatsApp message. My lord, kindly reads with me the second paragraph, my lord. High-end residential project being developed by Mr. Such and Such. We have stake in the property and obtained injunction from court last year, which is a wrong statement, my lord knows, in view of the fact that the suit was filed in respect of a different premises altogether. In spite of which, the promoter is openly violating the court orders by carrying out construction activities, my lord, number one. Number two, please be aware that he has not obtained RERA registration. Also, don't participate in this. Two of them are falsehoods, my lord. No order is subsisting in respect of premises number 2 Robinson Street, and number 2, the RERA registration certificate was already there and I have annexed it. It's a part of the records, my lord. My lord, I'm only praying that this order be made absolute, my lord.
What is there? Who is appearing for the defendant?
My lord, Mr. Jishnu Chaudhary was appearing with Mr. Snehal Kaprania.
Interim order is continuing or
Interim order is continuing, my lord. It is
till date?
my lord.
When
My
is
lord,
going
it
to
is
be expired?
till 23rd of April, my lord. By the
23rd?
last order, my lord, it was extended.
Okay, I am fixing on 23rd April. And
23rd of April, my lord.
so appearing for the plaintiff. None appears on behalf of the defendant. For the interest of justice, the case is adjourned. It is fine from the record. The interim order granted is already extended till 23rd of April 2025. Let the matter appear on 23rd.
I'm grateful.
April 2020. Next.
My lord, before that, may I have your lordship's kind leave to mention item number 31, my lord. Interim order
Item?
31, my lord. of
I
the
will take the interim order. I will take.
I had mentioned this matter yesterday, my lord. My lord, this is, my lord, for plaintiff's witness examination. But on the last occasion, my lord, it fell from my lord that I can opt for a commission, my lord. On that day, I did not have instructions, my lord. I have filed an application praying for my lord.
Who is for the defendant?
But I humbly beseech anyone can be appointed for it.
Have you served the copy?
Yes,
Who is
sir.
for the defendant? You are appearing.
Yes, Your Honor.
So, commissioner, appointment of commissioner. Any
No issue, Your Honor.
no issue.
Your Honor,
just regarding one, there was a previous mistake. Regarding that, I just wanted to highlight.
What?
Your
The
Honor,
order?
Yes, Your Honor. Just I wanted Your Honor just to give me 1 minute time. Your Honor, actually, last to last occasion, Your Honor has given one chance to serve the document for judge's brief. We have served, but they had not accepted that our documents just because of our written statement is not been filed. So, Your Honor, we had filed one GA general application 3-4 months prior to our our case. Your Honor, the only reason on 18th July, Your Honor, everything was affirmed with original side just because of my brother-in-law. My own brother-in-law was suffering from carcinoma, and I was not present in the month of August, and the file was with me. That was the reason, Your Honor, we have not been able to serve the written statement on time. After that, on 18th November, in the month of November, Your Honor has directed us, all the parties, to file the documents for judge's brief. We have given few annexures for judge's brief, which was firstly accepted. After 1 day, it was been rejected, Your Honor. My lord.
Vikas.
Your Honor, in annexures, every hospital bills, the entire that summary, everything has been attached.
No, that's correct. See,
Your
with
Honor,
regard to the inspection of the documents completed, framing of issues has been done. Now the witness is, now what you want?
Your Honor, just though I had served my annexures for judge's brief, the document.
It was inspected. Inspection was completed.
I think
they had returned.
I think that there has been non-compliance of orders of this honorable court, my lord. That kindly takes the order. They were directed to file fresh written statement with the order of 13th of June 2024. But this, my lord, repeated opportunities were given to them. They did not comply. And since, my lord, this was not filed, my lord, the question of taking further inspection did not arise. My lord. That kindly takes the order of 13 June.
June order?
Yes, my lord.
Defendant number 1 to have filed the present application. 2, in connection with submitted, the defendant have filed the written statement within the prescribed time after serving the copy to the. After going to the written statement, the defendant number 1 and 2 came to.
In their written statement, they had mentioned that documents relied upon is nil. That, my lord, will find in the order of 24th April.
Not disclose and said document along with the written. Counsel for the plaintiff. Though they have received the copy of the written but have not received the document, and in case would allow the prayer made by the counsel for the director to supply the documents.
That's why we have filed one GA.
Well, there is no written statement till date, my lord. That's the problem.
Mentioned in paragraph with the incident. Yes, that is on 13th of June.
Yes, another order kindly takes 24th April order, my lord.
24th April?
Yes, my lord.
Of
2024, yes, my lord.
Yes. Counsel for the plaintiff submit the discovery inspection document have been completed and the plaintiff have filed the affidavit document after serving the composition. Counsel for defendant, though the communication were made for inspection and document, and the counsel for the defendants had been to the office of plaintiff.
Page 2 of the order.
But could not conduct it in the place for that.
अभी तक आपका WS फाइल नहीं हुआ है क्या?
Extended for a period of 2 weeks.
Initially, WS was filed.
Huh.
That was without some documents.
Hmm.
So leave was granted by the honorable court to manage the documents and refile. That was not done within time.
It explained for the afterwards.
GA का copy class.
Yes.
Yes. It appears, my lord, a written statement was initially filed, but without any documents relied upon.
It was mentioned as nil.
Yes. Then again, leave was given, and despite leave, till date, it has not been filed. Therefore, they have taken out a GA, my lord.
My lord, an application has been, my lord, filed on behalf of us.
What is the application?
My lord,
GA number?
I'll just, my lord, GA number 3, my lord.
GA number 3 for what?
GA number 3, my lord, is I'm praying for acceptance of, my lord, my written statement, my lord, along with the documents. My lord,
My written statement is
That was
already
allowed. Kindly, have you order dated 13th June?
Yes, my lord, that was not done within time. My lord, that time was lapsed, my lord, on fault of my lord us. My lord, what happened, my lord, was my lord, my advocate on record, my lord, was outside, my lord, this my lord, out of station, my lord, on medical grounds, my lord. That I, my lord, explained, my lord, in my application. Just, my lord, list his documents, my lord.
ये लिस्ट में है आपका आज?
Lord, this was, my lord, this application was, my lord, mentioned, my lord, on my behalf, my lord. Lordship, my lord, instructed me, my lord, to place it, my lord, on when the matter is taken up, my lord.
Yes, issues were framed in
Yes, in
presence of the defendant also.
Yes, we were there, my lord. On that day, my lord, the leave was, my lord, prayed for orally. Your lordship was of the opinion, my lord, since the time has already elapsed, oral leave cannot be granted.
Yes.
After that, my lord, we have, my lord, formally filed an application. That is GA3.
Where is the GA3?
My lord, my written statement, my lord, was filed on was affirmed, my lord, on 18th of July.
18th of July.
July.
July 2024.
24, my lord.
WS तो सेम আছে না ऐड করেছো
খালি ডকুমেন্টস গুলো রিলাই করা হয়েছিল annex
July 24 you filed an application.
My lord, no, my lord, my written statement was affirmed on July 24.
No, when this application was filed? GA3? November 2024. And issue were framed on 11th September 2024. That is the problem, sir. Court, you persons are coming with an application, this court is allowing the application, you are not carrying out the application, and again you are coming an application.
My lord, I apologize.
What apologize? Now, I will not allow this.
My lord, kindly considers, my lord,
This type of the practice, sorry, sir.
My lord, kindly considers the grounds, my lord, and my lord.
What the grounds? See,
My lord, your lordship, my lord.
what the ground? The court, since April 2024, you are giving time by this court. Now 1 year has passed.
My lord, it was affirmed, my lord, long back. Could not be filed, my lord, only because, my lord, the department is not ready to accept, my lord, unless, my lord, it's
When November it was filed.
My lord,
November it was affirmed.
it was, my lord,
21st of
affirmed, my lord,
November.
20th November
20th November.
Yes, 21st November it was filed. And now we are on April. You are not pressed this application at any time. Your advocate and record has not got any time to mention the matter. You cannot say this court is not taking the mentioning matter.
My lord, personally, my lord, personally, I came, my lord, to mention the matter. My lord, your lordship
Not
was
to
of-
mention, and this court has not allowed.
your lordship was of the opinion, since, my lord, time has already been fixed in this matter, my lord, that is, my lord, today. That's why, my lord, the matter is-
Might be then last stage you came after the November.
after, my lord, the issues were framed, my lord, the
Issues were framed in September, sir. Thereafter, the matter was listed on 12th November, 12th February.
I don't think it was mentioned my lord after that my lord.
No, that's why they're not mentioned. Not mentioned. Whenever any matters which this court take the mentioning, they automatically the matter will be listed. One or the two matters this court is not allowing after going to the circumstances. Otherwise, all matters this court is allowing the mentioning. April 2024, the court has granted time.
you kindly, lordship, takes up the lordship grounds once, my lord, annexures, my lord, C, my lord, starts from annexure C. My lord, my advocate on record, my lord, his brother-in-law, my lord, was at the last stage, my lord, cancer patient, my lord, being treated in Mumbai. But he was there, my lord, after that he deceased. Eventually, my lord, he deceased, my lord, after that only, my lord,
Sir, he was diagnosed in April 2023.
My lord.
Correct. When he passed away?
On the 21st October 2024.
Then 21st October. But other advocates were appearing.
But
September they appeared. September you appeared.
September.
Then?
My lord, September, my advocate on record, my lord, was at that point of time, my lord, was not there, my lord.
Who is the advocate on record?
Mr. Mishra, my lord.
Mishra?
Mr. Shagar Kumar Mishra, my lord.
And who was suffering from this disease? My lord.
My brother-in-law.
Brother-in-law. Brother-in-law. Yes, Mr. Singh.
My lord, let them, my lord, bring on record. We'll put them to terms, my lord, because I don't want, my lord, this issue to be raised subsequently.
But I tender my apology, my lord. Shouldn't have been done, my lord. A court's order must be, my lord, complied in, my lord, terms of the spirit. My lord.
In the meantime, let them also give inspection, my lord, before the commissioner, my lord, examines my witness.
Then I will not first let all the inspection be. Otherwise, again, you will go to the commission. They will not complete on something else. So and so appearing for the plaintiff. So and so plaintiffs. So and so appearing for the defendants. The defendants have filed an application being GA3 of 2024, praying for leave. File written statement. Written statement already filed.
Already filed.
Fresh written statement with the documents.
To file fresh written statement along with documents. Good. Counsel for the defendant submitted. Submitted. Initially, the defendants have filed the written statement, but in the written statement, it is mentioned in the written statement, it is mentioned that documents relied by the defendants nil. Subsequently, the defendants made a prayer before this court that the defendant intend to rely upon the documents. Accordingly, the defendant has filed an application being GA2 of 2024. The said application was disposed of by an order dated 13th June 2024 by allowing the plaintiff, allowing the defendant to disclose the documents and to file a fresh return allowing the defendant to file a fresh written statement along with document. Full stop. In spite of the said order, the defendants failed to file the fresh written statement as well as to disclose the documents. In the meantime, this court has framed the issues and fixed the matter for witness action. Today, when the matter is taken up for hearing, the counsel for the defendant submitted the defendant has filed an application being GA3 of 2024, praying for leave to file a fresh written statement by disclosing all the documents. Full stop. Counsel for the defendant submit that the brother-in-law of the advocate on record of the defendant was seriously ill, subsequently passed away due to the said trauma, the counsel for the defendant could not take appropriate steps for filing a fresh written statement along with the documents as directed by this court. Counsel for the defendant submitted if leave is granted to the defendant to file a fresh written statement by disclosing the document, the defendant will file the fresh written statement along with the document within a week from date. Full stop. Counsel for the plaintiff raised objection and submitted the time and against this court has extended the time for disclosing to file fresh written statement by disclosing along with this file written statement along with all documents, but in spite of several opportunity given to the defendant, the defendant failed to file the fresh written statement along with the document, and he prays for rejection of the application. At the learned counsel for the respective parties, this court find that since the month of April 2024, this court has granted leave to the defendant to file a fresh written statement by disclosing all the documents. But in spite of the leave granted to the defendant, the defendant failed to file a fresh written statement by disclosing all the documents. Now the case is at this witness stage, but the defendant has filed another application praying for leave to file fresh written statement along with all documents. Considering the above, this court full stop. This court considering the above, this court is of the view one, final opportunity should be given to the defendant subject to payment of cost of rupees 10,000 to the plaintiff. Full stop. The defendant is directed to file a fresh written statement by disclosing all the document after supplying the copy to the counsel for the defendant within a week from date. Full stop. The department is directed to accept the fresh written statement, if any, filed with along with the document within a week from date, subject to scrutiny. Full stop. If the written statement is filed, if the defendant is filed the written statement along with the document, comma, your document has been
Yeah, they have
inspected.
taken inspection.
The plaintiff, the defendant is directed to disclose the original document to the plaintiff within a week after after filing of the fresh written statement, and the plaintiff has liberty to inspect the original document within a week thereafter. Full stop. On completion of the inspection of the document of the defendant, you file the judge's brief? No, you not filed.
Judge's brief it's ready, my lord.
Full stop. Both the parties are directed to file their judge's brief document within a week thereafter. List the matter. One week है ना? अभी कितना बोला? 1 week. 1 week, 2 week, 3 week. List the matter on 29th of 30th of April 2024 before this court for further consideration.
Very
good. Under the heading adjournment.
Deep
Under the heading orders. GA disposed of. Huh?
Lordship, with your kind leave, Lordship, I apologize for mentioning out of turn, Lordship, but my matter was fixed at 3:45 p.m., Lordship, today. I believe there's a resolution for 3:30
Which
p.m.
matter?
Lordship, item number 2 of my Lord's commercial list, Lordship. It was a part heard IPDP transferred matter. My other side is here, Lordship.
Item number?
Item number 2 of my Lord's commercial list, Lordship. It was fixed at 3:45. I believe there's a resolution for 3:30 p.m. today, Lordship. If my Lord can take it up right now, my counsel is online, Lordship.
Right now, other matters are there.
Lordship, if we always miss our turn, Lordship.
What can be done if you have taken the resolution?
I apologize, Lordship. Can be fixed on 8th April, Lordship, in that case, Lordship.
8th April खाली है? नहीं है. Who is for the other side?
Lordship, I am willing to do it even after 3:30, Lordship, if they are agreeable to it.
I don't know. The court will hear. If she will
Lordship,
not,
8th, Lordship. Then.
she will be thrown out from the bar.
But I just gave her the idea that matter, Mr. Chaudhary, and I
That,
constructed.
no, but one matter, I am taking matters. If both the parties are ready, there is no problem.
Chief has to rise for a reference, that's different.
That is different. If the bar resolution, if the members of the bar ready to argue the matter, do the matter, it's not
Chief had
difficult.
heard us till 4:30.
We are agreeable, Lordship.
But other party is not. And she is in difficulty.
I understand, Lordship. I am before my Lord.
कब है?
ठीक.
Before May, there is not, even 340 is not available.
3:45 is also not available.
Even 345 is not available before May.
Lordship, April, any day, Lordship.
That's what I'm telling. I will fix.
We just take your Lordship. We will take only 15 minutes. We've got written submissions ready. We've already filed that, your Lordship. You've heard the matter. It
Your
won't
other
take.
matter is also there for orders. I think it. Let it come in the list.
Lordship will not get a turn that way, Lordship.
Who is who will argue?
Respondent, madam.
You will argue?
Madam, my senior is also there.
Who?
Satrup Banerjee.
Satrup. Then he will be busy. He will be available or not?
Any day, my lord.
Any day. He will be available.
My lord, he has told me.
नहीं बात नहीं दो आज 22-23 तारीख पे 25th April So-and-so suffering for the plaintiff.
Appellant.
So-and-so suffering for the respondent. Though the matter is fixed today, especially fixed today at 3:45 p.m., but due to the bar resolution, the matter could not be taken of a hearing. Full stop. Let the matter appear on 25th April at 11:30.
Lordship, can it be earlier, Lordship? Because I have a matter in Delhi High Court on. Sorry, Your Lordship.
When?
So, Your Lordship, if you could do 9th or 10th or 11th of April, just
9th
15.
and 9th and my diary is totally full. 22nd?
Your Lordship, I have a matter which is going on a day-to-day basis on the 21st week. So that's why, Your Lordship, if even 15th April, Your Lordship, 15th April, Your Lordship.
15 I will take the whole day you can argue
15th is
the
a
matter.
local holiday.
14, 15, 18, all the 3 days are free.
Sorry. Lordship, 17th, Your Lordship.
11th April?
Yes, 11th is fine. Yes, Your Lordship. 11th is okay.
11th April at 11:30.
Thank you so much, Lordship. Much obliged.
Yes.
Passover matter, Lordship may take up. Both sides are here.
Why so many lawyers are there? Okay. Call the password. You do one thing. You give this any interim order extension.
Yes, interim order extension is there.
Then the members will be.
Item number 31, my lord. Interim
Item
order.
number
31 of your non-commercial.
Non-commercial.
My lord. This is the last order, my lord.
31.
Yes.
Record. Who is for the defendant?
My lord, I am for the defendant.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant number 16 to 21, 31 to 46, and 43 to 56. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier, the interim order which is going to be expired today is extended till 30th April 2025 or until further order whichever is earlier. List में है ना? Let the matter remain in the list. Yes.
But, an interim order, Miller, for extension, which is Miller till today.
Item number?
Miller, this is not listed before your lordship's list. Miller.
So-and-so appearing for the plaintiff defendant.
Miller, I am appearing on behalf of the plaintiff.
And defendant number 2.
I was, Miller, but because we are selling the same cause, Miller, both are brothers.
So you are appearing for
now
whom?
For the plaintiff.
But it will be difficult. Defendant number 2.
Let it remain as defendant number 2.
So appearing for the defendant number 2. He submit, though the matter is not in the list, but the learned counsel for the plaintiff and defendant number 2 submit that interim order granted earlier is going to expire today and paid for extension of interim order. In view of the submission made by the counsel for the defendant number 2, the interim order granted earlier is extended till 1st of April 2025 or until May 2025.
Lord, in this matter, may I beseech your lordship
or
for a
until further order whichever
sorry.
is earlier.
Lord, in this matter, may I beseech your lordship for a leave so that my learned advocate on record can file the wakalatnama. Your lordship will kindly see, Miller.
On behalf of?
On behalf of the plaintiff.
The counsel for the plaintiff prays for leave to file wakalatnama on behalf of the plaintiff. Let the leave is granted to file wakalatnama in the department within a week from date.
Yes. Leave to endorse code.
Yes.
Oh, order it.
Item
I'm
number
deeply obliged.
27. My lord, praying for extension of the interim order of status quo, my lord.
My lord, I appear on behalf of one set of the defendants, my lord. My lord, I can in principle not oppose the order of extension.
I thought you are telling that it is to be vacated.
Lord, may I just
may
I make one indulgence, my lord. The affidavit in opposition, there was an express direction on me. I am belated, my lord. May I seek for 2 weeks time, my lord. I shall indicate, my lord. The affidavit in opposition, extremely voluminous. I cannot take it upon myself. The senior advocate settling is not in Calcutta, my lord, in Delhi, Mr. Ray. My lord, I am stuck between the deep sea and the devil, my lord. Kindly, my lord.
Have a flight 2 hours journey.
No, nobody will. No, nobody will pay for that flight, my lord. Kindly, my lord, appreciates.
Appearing for the plaintiff. You are appearing for?
Lord, kindly. 2 weeks.
You are appearing for whom?
For one set of defendants. 1 to 7 and 9 to 11.
Appearing for the plaintiff. Appearing for the defendant number 1 to 7 and 9 to 11. What about the 8C? Nobody is there.
My lord, they are the
It is
alternate.
listed.
Yes, my lord, they are there.
Item number?
27. No, they're alter ego.
Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of interim order. Counsel for the defendant number 1 to 7 and 9 to 11 raise for extension of time to file affidavit in opposition. Counsel for the plaintiff raise objection for extension of the interim order. Extension of time to file affidavit in opposition. Had the learned counsel for the respective parties. Full list of the interim order the defendants number 1 to 7 and 9 to 11 are directed time to file affidavit in opposition by the defendant number 1 to 7 and 9 to 11 is extended for a further period of 10 days from date. The interim order granted earlier is extended.
Also extend the so pleases for the 8 series as well.
They have not come forward.
Number 8.
No, they have not sought. Your alter ego.
That's why I am praying your
Till 30th
You are
April
praying
2020
to on record.
or until further order, whichever is earlier.
Extremely
Let
obliged.
the matter. List the matter on 30th April. Yes, next.
Extremely obliged.
So grateful.
My lord, item.
I have affidavit bola na usme reply within 2 weeks, within a week thereafter.
My lord, item number 39 of today's list, my lord. Interim order is expiring today. I have given notice to the advocate for defendant.
Item number
39, my lord.
Sensation suffering for the plaintiff. Counsel for the plaintiff submit that interim order granted earlier is going to be expired today. In view of the submission made by the and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 1st of April 2025 or until 1st of April. May.
My lord, and next matter was item number 40, my lord.
No, let matter be remain in the list. Yeah, item number
40, my lord.
Item number 47.
Yeah, please, Your Lordship. Item number 30 of my lord's today's list. Interim order is expiring today. Was an ex parte ad interim order, my lords. No other.
Who is on the other side? Not
Ex
sir.
parte ad interim order, my lords.
Where
I
is
have
your
complied
affidavit
with
of service?
39.3. It's there with me. My lords will also kindly take this on record. It's item 30 of today's list.
डाल देगा. So item number
30, my
yeah.
lords.
So suffering for the plaintiff. Counsel for the plaintiff has filed affidavit of service. Let the same be kept with the report. Counsel for the plaintiff submit the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 1st May 2020. Is a commercial? No.
Non-commercial.
1st May 2025 or until further order, whichever is earlier. List the matter on 24th of April 2025.
I'm so grateful.
My lords, may I have an My lord, indulgence? one matter, my lord, item number 19, my lord, your lordship was pleased to, my lord, fix the matter in the 17th April, but my lord, Mr. Kankani, but my lord, Mr. Kankani, my lord, will not be available in town, my lord.
Okay, come on that day and mention, we'll see.
My lords, may I have the indulgence to mention item 23,
Ah.
my lord, appearing for the defendants.
Ah.
My lord, that called out the matter. I was trying to log in, my lord, there was difficulty at mine. By the time I came running and reached, the matter was over.
Okay,
My
so what do you want?
My
Your
lord,
name is to be recorded.
My lord, I mean, I was trying to log in, my lord, I just couldn't. Grateful, deeply grateful, my lord.
Was leading her, so.
Your name is to be.
Similar benefits maybe.
And my sincere thanks to the council for the other side.
Okay.
Thank you
Yes,
so
call the matter.
Thankful for the benefit to the left and the right.
Petition. Need, please, your lordship. Well, this is an anti-suit injunction.
Item number?
Item number 22. Where, my lord, my application under Order
Yes.
7, Rule 11, my lord, both sides, my lord, we had argued.
Hmm.
But at the last stage, my lord, it was, my lord, Mr. Bhattacharya, my lord, had pointed out to the court. If your lordship kindly takes up, my lord, the order of December 12, 2024.
Yes.
My lord, the objection which was raised was with respect to non-stamping before the notarial public. My lord, that defect we have cured.
Hmm.
But may I hand over a copy to my learned friend? And my lord, for your lordship's inspection, my lord, may I hand up the document? Your lordship sees the last page, my lord. There was 10 rupees which was deficient. It has been cured. And we also found out that, my lord, the apostle office, my lord, in the United States, they usually do not put the stamp. It is, my lord, for us, once we receive it, to get it stamped appropriately. Now, my lord, apropos this, my lord, now this defect is cured. My lord, we had contended that this suit is not maintainable for two reasons. First, my lord, the place of marriage, my lord, the place of marriage is admittedly outside the jurisdiction, that is Kulti. I had shown your lordship, my lord, the Special Marriage Act. The husband, my lord, stays outside the jurisdiction, Bardhaman. The wife, my lord, stays in California, as will appear from the cause title itself. The only reason, my lord, pleaded in the plaint apropos jurisdiction is that since the marriage got registered under the Special Marriage Act at Kulti, therefore this honorable court has jurisdiction. I had also shown your lordship, my lord, the Family Courts Act, that is, my lord, with effect from 1988, this honorable court, my lord, does not have the territorial jurisdiction or the subject matter jurisdiction apropos matrimonial disputes, because now the family courts have it, which is, my lord, within the local limits of the Bankshal Court. Yes. So, my lord, we had also placed reliance on that. I had shown your lordship, my lord, the Special Marriage Act as to when there is a dispute, what is the, when there is a dispute, my lord, which is the court, that is a district court, which has to entertain that. Over here, my lord, the husband has already filed a suit, which he says is the first suit for divorce, which is, my lord, outside jurisdiction at his native place. Now, my lord, the wife has filed a suit subsequently at California. Through this particular suit, my lord, the plaintiff husband wants to, my lord, stall the proceedings of the subsequent suit filed. My contention was, my lord, because this court lacks inherent jurisdiction, both territorial as well as subject matter, hence this, my lord, suit cannot proceed. I had also shown, my lord, one judgment referring to Modi Networks, that is the parent judgment on anti-suit injunction, to say that a person who is trying to assail anti-suit injunction case must himself be amenable to the jurisdiction, because the concept is like section 10 of the Code of Civil Procedure. In objection, my lord, it was one of the points which was taken was that since the decree which may be passed would be a decree operating in rem, that is the decree for divorce would be a decree operating in rem, that's why, my lord, this court can have jurisdiction. But that, in my most humble submission, my lord, may not be the correct proposition, because for the first reason, decree has not been passed yet. And secondly, my lord, if a decree for divorce is passed, subject to what falls from your lordship, my lord, it is a decree between both individuals, nullifying that particular marriage. It cannot be considered as a decree in rem like a probate application. A grant of probate is a decree is a decree and adjudication in rem. Apropos that, my lord, the same logic cannot be applied over here, especially in a case where, my lord, this court lacks territorial and subject matter jurisdiction. That was my most humble submission, and your lordship, my lord, had taken notes of that as well.
That's all.
That is all.
My lord, my learned friend has, my lord, indicated, my lord, my moot point of argument, my lord, that I have relied upon, my lord, a judgment of this honorable court to, my lord, argue that, my lord, what my learned friend says, my lord, that a decree passed in a marriage resolution case is not a decree in rem, my lord, probably not correct. And I have shown a judgment to your lordships, my lord, where it says, my lord, it's operate as an in rem. Because, my lord, in all practical purposes, my lord, a decree passed for a divorce, my lord, operate in all practical purposes as a, my lord, judgment. It's not only related to both the parties, because, my lord, it has an effect of, my lord, operating for other field as well.
So that he can marry once again.
That
person
even,
can marry
that
once
even
again.
also, my lord, my contention was that, my lord, only for, my lord, since, my lord, this decree can be executed in, my lord, Calcutta, my lord, this court, the choice where I should file it, my lord, rests with the plaintiff, my lord.
No.
Subject to, my lord,
matrimonial suit. See, yes. In the matrimonial suit, there are where the cause of action arose.
Yes, my lord. I am coming to that, my lord. To first part, my lord, as to that, that it is the choice, my lord, the plaintiff, subject to the fact that this court would have jurisdiction, he can, or any other court. If both court has, it is the choice of the plaintiff, my lord, where he should file the suit. But he says, my lord, according to me, I have a cause of action here, as well as in Bardhaman, I have chose to file it here. To defend
No, I
it.
am not saying he has a cause of action here.
He is not stated that
I'm
the
saying he
cause of
doesn't have a
action
cause
is
of
here.
action.
Yes, there is no cause of action. Only you are mentioning their address with regard to the advocate's office address.
My lord, in support of his submission, he has relied upon, my lord, the Family Courts Act, my lord, which says, my lord, all matrimonial disputes shall be filed before, my lord, the court where, my lord, the either marriage taken place or, my lord, the last residing together. My lord, kindly consider, my lord, this case before your lordship, the plain doesn't deal with a matrimonial dispute. It is only a suit, my lord, that in view of the fact that I have a prior suit, the suit filed in the foreign court cannot be proceeded with. Here, your lordship will not deal with, my lord, the matrimonial rights and liabilities between the parties. So therefore, my lord, the bar which is encompassed under, my lord, the Family Courts Act will not apply here. That was, my lord, my submission. And to that extent, my lord, I say, my lord, since it is, my lord, in the outcome comes in. The decree which could have been passed in superior court, that can be operated, my lord, since both are Indian, my lord, in even Calcutta. So therefore, I'll have a, my lord, cause of action to, my lord, file this suit before your lordship. That was the two moot contention. And the, my lord, the third point has today, my lord, submitted, my lord, the power of attorney, my lord, subject to correction, my lord, whether, my lord, when a stamp was not done and an application was filed, subsequent stamping would, my lord, cure, my lord, the defect of filing of the application. These are, my lord, only, my lord, three moot points, my lord. And you will also see, my lord, I have relied upon a judgment of Calcutta, my lord, that is at page 65, which says, my lord, 2019 SCC online, my lord, I had relied on. This is the point, my lord, paragraph 65,
yes,
where the court has dealt with, my lord, position situation, my lord, if I read, equally merely because an injunction is sought against a foreign court or a foreign promoter, and not in person and against a party amenable to the court in season of the prayer of such injunction, it would not make a prayer of injunction infructuous if the applicant meets the highest test otherwise required. The court may mold the relief and issue injunction in person. There is a line of some judgments, including noli velicia, that an intesute injunction and anti-arbitration may issue in personam only against a party amenable to the jurisdiction of the court issuing the injunction. Such amenability need to be seen or tested at the time of issuance of the injunction, but may also be seen from a different perspective. If such injunction is sought against a foreign party or body amenable to the jurisdiction of the court, the amenability of foreign party to the jurisdiction of such court may also be seen in the context that the foreign party coming on a later date to enforce the foreign decree or foreign award in this country. So, my lord, the decree which could be passed, my lord, can be enforced here. So, therefore, this court would have jurisdiction, my lord, to, my lord, pass an order, my lord, in an injunction, my lord. That was, my lord, my moot point, my lord. Yes, my lord. That was shown, my lord, and this is my submission.
Very short reply, my lord. I'm very happy to see this is one of the first judgments which got reported where I had appeared. This is the Devi Resources and led by Mr. Dhruvo Ghosh, my senior. My lord, this is complete, facts are completely different, my lord. And in this case, my lord, one of the parties was truly amenable to the jurisdiction that was having its office within the jurisdiction of this honorable. Such is not the case here. My learned friend has very correctly said that to assail an anti-suit injunction, and I have relied a judgment, Modi Networks, the party must be amenable to the jurisdiction of this court. Here, my lord, just by saying, and as had correctly fallen from your lordship, camping at the office of the advocate is not the permanent place of residence or the dwelling house. That cannot be treated, my lord, as amenable to the jurisdiction. If that is not there, then nothing remains. Those, my lord, are my most humble submission.
okay.
Your lordship may record, my lord, the defect has been cured pursuant to leave given by your lordship by the order of December 10, 2020.
Yes, anything further? That's all. Sense suffering for the plaintiff, sense suffering for the defendant. Counsel for the defendant has placed the original power of attorney showing that the deficit court fee has been paid and has been apostilled by the appropriate government. Counsel for the the copy of the said power of attorney also handed over to the learned counsel for the plaintiff. Counsel for the plaintiff has raised an issue whether subsequent to filing of the suit, subsequent to filing of the wakalatnama, if the power of attorney has been properly valued, can be taken into consideration at the time of filing of the wakalatnama, the power of attorney was with the defendant or not. This is the issue.
It was defective, non-step.
Non-step, correct.
But this is, my lord, my reply to this is that
Issue,
it is, my lord, pursuant to your lordship's order.
The plaintiff has raised the issue whether subsequent to deposit the stamp duty, comma, the same can be said that the power of attorney was available with the defendant at the time of filing wakalatnama. Full stop. Counsel for the respective parties have concluded their argument as CAV.
Only wanted to say that the wakalatnama has been filed by the party concerned.
No, I will see it.
Fine.
The only one thing, Milord, if
Deeply
your
obliged,
lordship is not with me, Milord, kindly leave be granted to Milord then in that case to approach the court of competent jurisdiction. Because it cannot be rejected, Milord, it can only be transferred.
Okay.
Because plain, Milord, for lack of jurisdiction cannot be rejected. It would be an order 7 rule 10 situation in that case, if my learned consent.
I'm deeply obliged, Milord.